Madam, you are sitting, both of you are sitting for that order? For that order? Or any other matter? Tomorrow. Tomorrow, it is under process.
But tomorrow I'm out of station.
matter. No,
May I
you are not.
request day after tomorrow.
We'll see if you have anything to be done tomorrow. What? Why? Pronounce. So virtually pronounce. We are in the process of deciding what to do. We don't.
Just one submission on it. Uh,
only like to say that the orders have been that land has to be allotted to the petitioners, my lord.
Yes. List 3, seal number 1.
The matter I had mentioned yesterday, my lord, for permission for felling of trees.
Lordship, we appear for the petitioners in this matter. We have been served with the application yesterday, your lordship. We require some time to peruse the application and file objections. It may be had on the first week of reopening, your lordship.
Everything that is required, my lord, in terms of your lordship's orders have been complied with. It goes to the tree expert committee gives a report. After that, it goes to tree officer then decides. But this, it can't be changed, my lord, to a scenario where we have to take the permission of my learned friends to actually allow us to cut and fell trees.
Your lordship,
The
since
total number of trees, my lord,
Your lordship, since the petition was filed, the standard practice is that 2 weeks' time, 15 days is to be granted to peruse the OM and see if necessary compliances have been undertaken, your lordship.
compliance is
We-
there on record.
We only request that it may be posted on the first week and we will peruse the OM and file our objections to it.
Holding up a public project, like, my lord, this is the airport metro.
For 10 days. 8th of, not 8th, the next 15th of Jan.
Can it be 8th itself, my lord? It may not take more than 1 minute. Because every other application they've consented, I don't.
Hey, Mr. Chairman, some days are passed.
know, 50.
List 1.
At the request of learned advocate. That's original petition. This is which I?
8 of 24.
8 of 20. So order may be in 8 of 24 only. At the request of original petitioner, respondent will send out.
Yes. List 1, seal number 2, contempt matters. Nanjar Reddy PM.
It's what is. Excellent.
Yesterday, Chairman, he was working. Though there was an interim order of stay. And also, my lord allowed the request until the regular recruitment is made. They should continue. Only in respect of one petitioner, my lord, at page 79. Others have been continued in the same writ petition.
So notice was received here?
Not yet, not yet,
Not yet.
not.
3rd March. So early, little early. February 12,
Oh, bless.
notice.
Seal number 3. Mr. Keshav Murthy B. Seal number 3.
Since we have filed our reply in this matter. Affidavit notes.
Reply.
Please. These are, this matter pertains to outsourcing employees, my lords. who are not employed by the government, but are employed by the agencies.
So what was set aside by Learner Singhal? 18th March 19, what is that endorsement?
No, it's, the order referred is, 55, writ petition number 5563 of 2020. But I just have this, judgment here, my lords. Only says that it has to be considered by respondent number 1. And chief officer of the municipality is not the authority to consider the representation, and therefore it has been set aside. May I produce that judgment of 55363 minutes?
They are not here. Keep back.
Please.
2/3.
This is number 4, to Vasant Kumar HT.
Complaint by. The impugned order passed by the learner single judge. Page 12, my lord, operative portion of order, page 12. There is a direction to consider the representation of the petitioner within a period of 8 weeks, failing which the BDA shall pay the petitioner rupees 5,000 per month till allotment is made. No allotment is made, my lord. The learner single judge given direction to issue the allotment letter, failing which the BDA has to pay rupees 5,000 per month as a penalties. Till the no allotment has been issued, my lord.
Take the 13th.
Seal number 5. To
Lordship.
Bhartiya GS, party in person.
Lordship, this honorable court is a contempt petition. I have complaint number 1. This honorable court learned single judge, passed and harder, directed the Tahsildar of Hoskote specifically to regularize and issue Sagol cheat against the unauthorized cultivation of our land.
3rd March. Notice.
Obliged, my lord.
Seal number 6, to Vijay Kumar.
Order.
May I please? I appear for the complainant's counsel. The order, breach of which is complained of, may be seen at page 15, annexure A. Matter pertains to grant of TDR certificates to which the petitioner is, the complainant is legitimately entitled. In fact, this is the 3rd round of litigation. Right from 2013, he has the complainant is knocking the doors of the BBMP for
Notice
TDR.
Third learned regulations, notice returnable. Which date?
Would it be early date? It's already nearly a decade.
17th February.
17. This is number 7. Seal number 7, to M. Krishnappa.
I'm appearing for complainant, my lord. In this case, this honorable court, as per annexure A, my lord, has set aside the order of suspension suspending the complainant, and he was directed to be reinstated with all consequential benefits.
11th February.
Public PL matters. Seal number 8, to Parameshwarappa CT.
But may I appeal? But this is a case, my lord, where 20 persons of a village have filed this petition, my lord, for removal of the encroachment in the land reserved for the, my lord, Hindus burial ground. See,
about 15 acres is reserved, my lord, say that is being enforced by the other public. Therefore, my lord, this petition is filed to direct the respondents, my lord, the deputy commissioner, Tahsildar and the adjunct commissioners to remove the encroachments, my lord. There is no other place except this, my lord, for the purpose of burial ground. This was there, my lord, since 1989-90. Now it is being encroached, my lord. Annexure A is the blood,
So
the
what kind
document
of, what
which
kind of
shows
encroachment is there?
blood.
What is the nature of encroachment?
Blood, they say they are, for the purpose of cultivation and other things, they are using it.
How do you say that?
Blood,
On what basis you are saying that?
blood, I have produced the photographs also, blood, in addition to the representations already given to the blood authorities. You will ask me kindly see photos at page 52, blood. 52 and 53. Shrubs are also there. It's being used for that. Representations are also given, blood, on the.
Who are these private, who are these private respondents?
Blood, see, villagers, blood, who are residing there adjacent to that land, they are using. It is being done in 2 survey numbers, blood. Annexure A and B, blood, discloses this particular land is there.
The allegation in this public interest litigation, as highlighted by learned advocate so and so leading. Is that survey number, land survey number 29.
20 and
Measuring
120.
10 acres and 27 mutas, and survey number 120. At measuring 5 acres and 28 mutas, situated at Chaula Hiriyuru village,
Chaulahiriyuru,
Padur Taluka, Chikmagalur district, is a government land and has been, and that the said land has been reserved for crematorium as per the orders passed by the Assistant Commissioner, Subdivision, Chikmagalur. It is the grievance that the said land used to be crematorium is encroached upon by the villagers, and that they have been carrying out agricultural operations to their benefit on their land, which renders the, which has resulted into difficulties and hardship in cremating dead bodies at the crematorium. Road is blocked. It is encroached, the road is also blocked.
blood encroached, blood.
In the facts and circumstances case, notice returnable on 11th February, say 28th February, from learned additional government advocate accepts notice
Along to respondents 28 to 30.
on behalf of respondent 28 to 30. Full stop. 5 of ad interim observation. It is directed that the learned additional government advocate shall solicit a report from the Deputy Commissioner, respondent to the hearing, Deputy Commissioner Chikmagalur, respondent for the hearing, it's not respondent, Deputy Commissioner Chikmagalur regarding the alleged encroachment on the cremation land, which may be produced on record.
Obligement.
Seal number 9, to Gauri Shankar, 14%. Seal number 9.
Feedback.
Seal number 10. To Siddhanu
Petitioner,
Vishwanath,
kindly pass over this matter.
What is it?
Encroach the canal of public interest. Kindly pass over this matter. This under submission.
After vacant. Send over to 11th, 12th February.
yes. Seal number 11. The Naman,
Is your lordship. It's a minor office objection that my rejoinder, the second set of the rejoinder is not on record. May I just pass on a copy of that? My lords, my entire case is captured by your lordship's order, my lords, dated 20th of August.
In fact, my lords, this should be resolved, my lords. Cabinet subcommittee has been constituted.
No, what is the subject matter?
Constitution of
Civil Services
Civil
Board,
Services
in
Board.
terms of the directions of the,
The cabinet, before the cabinet subcommittee, my lord, they should take a decision in a month or so, my lord. Probably it maybe kindly have it.
let's,
It's constituted.
No, it's not cabinet
may I
subcommittee.
just make, of course, my lords, if the advocate general is saying I can't dispute it. But the only thing is in 2014, Cabinet Subcommittee was constituted, another writ was filed, my lords. Thereafter, my lords, the decision taken therein was withdrawn. Now, my lords, it's been nearly 8 years since, my lords, the decision came and since the first committee was constituted. My only request is this, now that the session is in progress, my lords, if the decision could be expedited.
They are bound to it, the Supreme Court did it.
In fact, I've personally I've given an opinion that it has to be.
At the request of learned advocate general, who Shall I record that steps are afoot?
Your Lordship may say that it is before the cabinet subcommittee, my lord, the decision will be
That
taken.
is, object matter is pending before the
Cabinet subcommittee, my lord.
That will be 6 time to take further instructions. The request is exceeded to 10 or to 20th February.
Please,
Right.
by then, my lord.
Could it be in the month of January?
So let-
Since- my lord,
February, my lord,
My-
that will, we don't want to seek any further adjournment, my lord, let it come on.
10th February.
Very well.
Green bench matters. Seal number 12. S.Y. Shivali.
It's a matter pertaining to deemed conversion under section 95(9). Covered by lordship judgment produced at annexure H, page number 50. Serial number 35 also identical. Serial number 35 also deemed conversion.
35 also,
35.
this and 35 both.
35.
Yes, yes, the same.
My lord, provided the application is filed and pending, my lord.
So 35 also disposed of. The same.
Yes, ma'am.
Much.
Seal number 13. Sir Ravindra Gajaram Kulle.
Please, my lords. Herein, I am seeking for direction to consider my application, representation, producer annexure M and N to obtain revenue and forest NOCs, my lords, on the ground that petitioner was previously granted 2 quarry leases adjoining, and a small portion is left in between both quarry leases. And after amendment dated 17/3/2023, in the interest of conserving the mineral and exploration, Rule 8R4 was amended. Thereby, I am entitled to get that portion also a quarry lease. I am willing to abide by all conditions, my lords. So even after making an application so far,
10, 12.
NOCs were not obtained. And whereas the deputy director has forwarded his request on way back on 30th April 2024, my lords. It is produced at annexure F.
Will be appearing for forest department also
Yes, ma'am.
and take instruction.
Please, my lords.
Notice returnable on 10th February.
Obliged.
Sorry for the learned additional government advocate, Ms. Srimati Neelofar Akbar, who accepts the notice on behalf of the respondent state and its authority. Take instructions in relation to the grievance of the petitioner, more particularly with reference to prayer 14 capital D of the petition.
Please,
My lord, I beg to pardon, sorry for the interference, ma'am. A serial number 10, my lord, it's a PIL, my lord. Serial number 10, just called out, my lord. I'm held up in another one court. It is urgency for here the matter, my lord. PIL, my lord. My lord, it is a
It is kept at 2.
encroachment of road and set up the petrol bunk, my lord. Already construction is going on, my lord. May kindly hear the matter, my lord. Please, my lord.
No.
Encroachment of Raj Kalwe and they have formed the road, my lord.
So
It is a
much-
public interest litigation. That's why, my lord, I request this court, my lord.
Can be in the
Already they formed the
Come at 2/3,
Please, my lord.
2/3. Not in the middle of the board. It can
End
come
up
at
in-
2:30 in the second half.
Please, ma'am, please.
Number 14,
My lords,
Shri Gaur.
this matter pertains to the consumption of electricity in the crusher unit by the petitioner. Similar petition was filed before your lordship, my lords. Your lordship even passed the order for that, my lords, if me permit. My lords, give the petitioner the liberty to file the notice, file the reply of that notice, my lords, which was passed by the respondent number 3.
Forty-four, 4. All like this one. What is your name? Will be okay.
Yes, name told me. School. So writ appeal matters, cell number 15, HR Vishwanath.
For the
Lord.
caveat respondent.
Here for the
Done.
appellant, my lord.
So
In this petition, I sought for the relief of stay of
delay of 31 days, not
annexure.
delay of 31 days, will issue notice in the. What is it?
My lord, one submission. One submission, my lord, as against the same impugned order, my lord. A writ appeal of 356 of 24 was filed, my lord, and came to be rejected by this honorable court, my lord. It's as against the same impugned order and in respect of the same survey number, my lord. The appellant before your lordship sought to be impleaded in the writ petition. Their application came to be rejected, my lord. They stand on the same footing as the appellant in 356, my lord. My lord, that is the order in writ appeal 356, my lord.
We have got,
Very well.
it is rising out of same one.
Arising out of the same cause of action in respect of the same land, my lord, because the appellant sought for impleadment before the writ court, my lord.
Order is different,
No, my lord, the
common order.
common order, my lord. The lordship sees the writ appeal 356, my lord, the Durgamba Educational Trust, my lord, they were the petitioners. They claim to have purchased the land from the present appellant, my lord.
Without made be as a party in the writ petition as well as the tribunal, before the tribunal, they passed this impugned order. The property stands in the name of the appellant. In spite of that, while passing this impugned order by the tribunal order, has not visited the spot and they are not made any spot inspection and whose name the property stands.
So you are arguing the main appeal?
Yeah, appellant, yes, my lord. My My lord, in volume number 3, page 943,
Condoning delay.
RTC stands in the name of appellate. My lord, virtually the land was granted by the then kings of Keldi, rurals.
Who are you?
I am the appellant, my lord. I am the owner of this property.
You are the
Owner.
owner.
Yes, yes, my lord. I am Matadipati of Sri Ramalekeshwar Mutt, for which the kings of Keldi gifted these lands in the year of 1563.
You are which respondent?
My lord,
Your original respondent,
original.
respondent number, which number?
They are that made me as a party in that tribunal, my lord. Even that writ petition, I filed an impleading application that was rejected because, my lord, when the property stands in my name, somebody has filed a writ.
Page 104, my lord, page
Writ
104.
petition. In my lord, even the entire process and order of the order of honorable single judge is deviated, vitiated because that
The Chandra Muleswara Shivacharya Swami.
yes, my lord.
Who died?
Yes, sir.
You passed away.
My lord.
As per the finding,
You are Chandra Muleswara Shivacharya Swami.
Yes, my lord.
You left for heavenly abode on 28/9/14.
If
You left for heavenly abode on 28/9/14.
no, my lord,
Nine.
that was questioned before this honorable court. This the court all won the honorable the then Chief Justice of this honorable court.
We do not know.
Directed.
Don't
He is
mention
still alive. He is alive, my lord.
dismissed the appeal on the ground of your.
No, my lord.
Don't
That
mention any,
writ appeal.
don't
writ-
mention judge of any. name
No,
of
my
any
lord.
judge.
In writ appeal 39/27 of 17,
Please desist
this
from
honorable court,
mentioning,
whether the appeal was filed by
please stop. Please desist from mentioning any name of any judge, any chief justice of the High Court of any High Court while arguing a petition. Yes, proceed. Be in your
Sir,
discipline.
my lord, with great respect, I am submitting that appellant was filed a RA-BNA 1516 of before Assistant Commissioner Bangalore in respect of another survey number 152 of Jharkhand Elenka village, my lord. In that writ petition, that respondent filed a writ petition 52/983 of 2016, where saying that the appellant was dead. When I appeared before this court, this honorable court directed me to file affidavit stating that the appellant in RA-BNA 15/16 is alive. Therefore, this honorable court was dismissed that writ. Against that writ petition, my lord, writ appeal 37/29 of 17 filed before this honorable court, in which this honorable court directed whether the appellant was alive or not. If appellant is alive, Assistant Commissioner shall pass an order on merits. Thereafter, the Assistant Commissioner called that appellant, Chandrabala Shivacharya, who present before the Assistant Commissioner. They passed an order that Assistant Commissioner is alive.
All are appearing. All parties are appearing.
my lord, I am representing the government, my lord. My learned friend is appearing for.
R7, R8 and R10 to see.
On
So
KVX.
all are appearing.
On KVX.
Yes.
Thereafter, my lord, in another matter, wherein the KDB awarded 1 lakh 100 crores, in which in LAC case 51 of 14 and 48 of 14, I am the seventh claimant. Somebody, a stranger who was a driver in my mutt, a school van driver, made a application under Order 22 Rule 4, saying that I am the successor of the deceased Chandramala Shivachara Swami. In spite of that, he is alive. Thereafter, I contested in 51 of 14 and 48 of 14, wherein this Honorable Civil Court saying that the Swamiji is alive and allowed him to come on 12th claimant. He is still alive, my lord. That one Shivlinga Shivachara Swami of Kunandur, Udedmat, Tirthali Taluk, Shivamoga district, expired, dead on 28/12/2014. Taking advantage of this, my lord, this a driver who was serving as to bringing school children, he got admitted this Chandramala Shivlinga Shivachara Swami of Kunandur, Udazmat, in the name of Chandramala Shivachara Swami of Ramalingeshwara Mat, and obtained death certificate. After death, that Shivlingeshwara, the junior Swamiji, Pandit Pandit, my lord, it's a dehydration. I am extremely sorry, my dear. Pandita of the Shivachara Swamilu taken the dead body to Kunandur, Udazmat, where he was buried, that is cremated. For against this, somebody has filed a complaint that a dead person is appealing before very several courts, for which thorough inquiry was made and given a report. Police, dead person is not Chandramala Shivachara Swami. That dead person is Shivlinga Shivachara Swami of Kunandur, Udazmat. This is the police report is there.
So now what on merits?
Merit?
What on merits?
A merit, my lord. That is Chandramala Shivachara Swami is still alive. That is why he made an application, impleading application in writ petition 5993 of 2020. That was rejected. Against that order, I filed this writ appeal. My lord, the Honorable Justice who passed the impugned order in writ petition 5993 of 20 was appeared against the Mutt when his lordship was practicing as an advocate in WP number 21904 of 2004. I brought to the notice of his lordship that this court is disabled to appear. In spite of that, taken, not considering that.
You have to,
Lord,
please take your seat.
Lord, the contention is that, my lord, the Mutt has lost its title, my lord, basically. On the question of locus standi, finding has been given that they cannot maintain the petition, my lord. And insofar as the impleading application is concerned, my lord, page number 104, my lord, paragraph 67 and onwards,
My lord,
a finding has been recorded.
issued by this honorable.
Now your learned friend is arguing. Yeah, yes,
Kindly see page 104, my lord, paragraph 67,
104,
104, my lord.
yes.
Paragraph 67, my lord, is the consideration of his application for impleadment.
Go to bar. That's all. Anything further?
My lord,
Anything further?
my lord, that death certificate, that is 28/12/96, issued in the name of Chandramala Shivacharya, died on 28/12/96, is challenged. Another, that Chandramala Shivacharya is a son of Veeraya. That Chandramala, other Shulige Shivacharya, dead, really dead, 28/12/96, 2014, is son of Veeraya. That against the appellant death certificate is challenged, is pending before Shivagas. Two death certificate issued on the same date. So same, so one same father.
Very well. Heard learned. What is your good name? Heard learned advocate Mr. So and so for the appellant. From a learned additional government advocate Mr. Harish for the respondent state and authorities and learned advocate
Shivram.
Shivram for
Caveat respondent Subramanian, advocate.
on caveat
Subram.
and we have for respondent number. So we're keeping for orders tomorrow.
My lord,
For orders tomorrow. We'll dictate the order. At 11.
Please.
You will appear. Either will dictate or will pronounce the order, whatever.
Very well.
My lord, is a government appeal, my lord.
State appeal.
Delay.
Delay is there, my lord, and there's a connected writ appeal in 1367 of 24, my lord. Identical, same issue is involved, my lord.
Notice returnable on 11th February to be listed. Notice returnable to be listed with connected writ appeal number 1367 of 2024.
23.
Heard learned additional government advocate, Mr. Harish, or the applicant dash appellant.
December 17. Mr. Shiv Prasad Santanagoda.
For the appellant.
Hmm.
The appellant was arrayed as the petitioner.
Serial number?
17.
Notice returnable on 17. Delay on 4th, on 5th of March. Yes, next.
Request for a
Also
date in,
18.
may I make a mention?
Same.
Lord, may I make a request for a date in February? For this reason, matter pertains to issuance of pension to retired employees from the SBI Bank.
18th February.
Please, this March, my lord, they'll issue the pension that. Grateful.
As a pension,
Pension.
4th February.
Please.
December 18. So Prasad Hegde, KB.
Land Council, there is a delay, of course, my lords, of 85 days.
Notice.
Only one, may I make one request? Cost has been imposed. Can I at least seek, my lord, still, at least the cost to be stayed, my lord? That's all. Or the present. Page 47, running page 47, para 10.
The present writ appeal which seeks to challenge, in which the appellant seek to challenge judgment and order dated 19th March 2024. Dismissing the writ petition number 9180 of 2022 comes up along with the application for cornership delay. Delay is of 97 days. Full stop. Notice returnable on,
That's 85 days delay.
sorry, 85 days. Notice returnable on 13th February. Full stop.
8 to 12. no?
While learned senior advocate Mr. Panendra would submit that in the facts of the case, the impugned judgment and order is required to be stayed. At this stage, none of the aspect on merits could be examined since the appeal is at the delay stage. However, it is noticed from the operative portion of the order of learned single judge that that a cost of rupees 1 lakh is imposed on the petitioner. Full stop. In the totality of facts and circumstances, when the appeal is under consideration, the directions regarding payment of costs shall remain in abeyance.
Lords, in addition to notice, can I take out for 8 to 12 on the council who represented
In addition to normal mode of service,
Mr. T.P. Vivekananda, council who
the
represented
permission
8 to
for the
12.
appellant to
respondents.
serve the counsel who appeared before learned single judge
Please.
for the respondents.
Seal number 19. Mr. Chandrakant R. Bole.
I appeal for the appellant, my lords. Here is held up in another court, my lords. Request.
Pardon?
Senior is held up in another court, my lords.
And it is not that, then it will go after 18th February.
Seal number 20. Patil Dayanand, appellate.
My lord, day before yesterday, we have completed our argument, my lord, and today it is posted for orders.
Uh,
30 years delay in.
Two more.
Please.
Lord, in this case, can I produce two judgments alone? In this case, can I produce two judge? In this case, can I produce two judgments, my lord, which talks about time?
No, when it is the stage, when it is at the stage of judgment, you are producing judgment. Give to other side. Give copy to other side.
I'm giving.
No judgment. No. After it is kept, no, don't take. At this stage, you can't produce any judgment.
It's pertaining to delay, my lord. that
Maybe,
delay.
whatever. It is heard and kept for orders, then in between no judgment. Tomorrow for orders.
Commercial appeals, SL number 21.
Not for the appellant, the 6 days delay, my lord.
No commercial appeal, no time. It will all go to beyond.
Give it a
vacation.
response.
Take your date.
There's no stay, my lord. No request for stay.
So what do you want?
Any date.
So any date, my-
Any to give, choose your date, depending on the urgency. Yes. Give the cheat and date will be given.
please. my lord.
Serial number, date. 26.
Serial number 25, I'm being led by Mr. Puvaya, my lords.
I'm
This is
here,
very
my lords, on
emergency.
25, my lords. May I just make one request?
My lord,
I'm Lords.
appearing for the.
My lords, I have an urgency, my lords, given the
There is no voice reaching.
We can't hear you, Mr. Puvaya. I'm appearing for the
My lords,
respondent.
I hope I'm audible now. I'm sorry, my lords.
Yes,
My lords, I'll just take 2 seconds. I'm conscious, my lords, that your lordship's board is heavy today. But the problem for me, my lords, that there are 2 findings against me and a direction to deposit 2.5 crores in a section 9 order, quite contrary, my lords, to the stated law saying such an order could not have been passed. If your lordship gives me,
Keep it immediately on reopening, 6th.
my lord, 6th Jan, my lords. Grateful.
I'm grateful.
Grateful.
I'm grateful.
My lord, I'm appearing for the respondent in this. I've got a copy of it yesterday in the second half of the day. I shall file my objections in this matter. If it may be taken up in the first week of January.
6 Jan is fine, my lords.
My lord said it's 6 January.
Obliged, my lord.
Grateful.
I'm so very grateful, my lords.
My lord, with respect to
26
serial number
urgent.
24, my lord, I have sought for an injunctive relief against the respondents. There is urgency in the matter.
Which one?
Serial number 24, my lord, coming under the commercial court matters, sir.
What is
Commercial
the
appeal.
urgent?
My lord, here the respondents are using the goods belonging to the appellants and they are using the method of passing of my goods in the name of other firm, my lord, in the same place, sir. My goods are, so,
It can wait till
Have serial number.
my lord, tomorrow if
25th.
possible, my lord.
not possible tomorrow.
I have filed 2 IAs, my lord. The product, the goods has been continuously sold by the respondents.
23rd January. No, that's
First week, my lord, kindly. There is arbitration as well. First week, my lord, kindly.
15th January.
Obliged, my lord.
Lords, apologies. In serial number 25, there's a connected commercial appeal listed. That also may be listed on the 6th.
Which is that?
I'm fine.
My lord, the other commercial appeal arises out of a different arbitration application altogether. Though between the same parties,
Then request on that day, we'll see the.
on that day, they may make that
Very
request.
well, very
I'll
well.
Get my
Very
instructions by then. Obliged.
26 urgent, serial number 27. Mr. Sudhindra, SCA,
I appear for the respondent number 6 and 7.
serial number 27. Mr. Sudhindra,
This is a matter which had been preferred by the petitioners, challenging the notification at J series to the petition. The J series notification state was promulgated by the state government, stating that, my lords, lease mining lease in respect of lands in survey number 31 to the extent of 1 acre 6 guntas and 2 acres will be granted to respondent number 6 and 7.
It is coming up for the first day.
No,
Oh my
my lord,
God.
it was argued in August, my lord, on 12th August
12/8/20
2024.
On 12/8/24, it was
Oh.
argued, where they are claiming that the mining which was granted to me
Correct,
is
correct.
disturbing their
Yes.
deity.
So then
Whereas,
The
Okay.
date is shifted.
please, my only submission is this, my lords. My lords may kindly have page number for a moment. 107, my lords, the translated copy is 110. That survey number 31 has been previously granted to, my lords, 10 people. 10 people have worked in that place. The map is at 109. The total extent is 30 acre 22 guntas, of which 24 acres 22 guntas have already been granted previously, mined previously. The licenses have expired. Now somehow 2 of them are granted, that is respondents 6 and 7 are granted to the extent of 1 acre 6 guntas and 2 acres, please, my lords. Before we could start, my lords, they claim that there is a deity. We preferred, my lords, a suit for injunction. This that landed up before this honorable court in writ petition in GMCPC, my lords, and a injunction was granted in favor of the respondents. And subsequently, though such being the case, there were violations from the petitioners. The SP was, my lords, directed to enforce this. Though such being the case, today, my lords may kindly have the photograph, which my lords may find at page 300.
Petitioner he is not here.
My lords, they are creating roadblocks. And secondly, my lords, there is a village map at page number, my lords, 358. There is a road. They have created a road graph, and for 7 years, I have not been able to work my mine, please, my lords.
Learned advocate for the petitioner is absent. Today also, when the petition was listed and called out. Learned advocate, Mr. So and so, the respondent, basis for urgency. To submit that basis for urgency, full stop. It is observed that unless the learned advocate appears and argues the case on the next date, it shall be liable to be dismissed for want of process. Agay, you are there.
Please, sorry, my lord. Kindly this matter, next week, my lord, my senior is going to Dharwad.
Senior is not there, not well.
My lord,
Senior is not well.
going to Dharwad, my lord, that's going to
Coming.
Dharwad. Today is Dharwad.
On his way. On his way from Dharwad.
Please, my lord.
The senior is on his way back to Bangalore to Dharwad, from Dharwad.
No, Bangalore, my lord.
Bangalore.
Bangalore.
Very well, we'll wait 2:30.
My senior is going to Dharwad.
Going to Dharwad.
Please, my lord, today morning.
You should take this matter also along with him.
Sorry.
On 12/12, they had submitted that he had a heart procedure.
Please.
Now you argue in the next time, whether we will dismiss for want to proceed.
Please.
7th January.
Please.
Published. If I may just seek one indulgence.
Same order.
The state, I have also asked, this being a PL, I have asked for certain prayers also, my lords. There is a roadblock which is done by the petitioners. It is clearly depicted that it is road. Can the state be put on notice to submit as to what they are doing with respect to that?
On that day, you have filed your reply.
I have filed, my lord, we filed it in 19. But this
Published.
is something new that they are coming up with. Unless it is in writing, I will not be able to
There
get
are
the
FIRs
instruction.
which are registered by the state themselves.
Please
Submit,
produce them.
make your submission, right.
I will on 7th.
You want the papers? This petition
Well, papers now.
to be taken to Dharwad.
Public.
Number 28. Parani.
The petitioner.
Number 1.
I appear for respondent number 4, your lordship.
As a correspondent, I request for some time to file statement of objections.
No urgency. It will go to 5th of May, 5th of March. Yes. Oh, about
Till number 29. Just Sanket Shankarappa Ambali. Till number 29.
My lord, I appear for the petitioner in this matter, item 29. Lords, on the last day, there was a direction to us to serve the copy of petition to my friends, and my lords, I have served to both of my friends.
Petition.
On last day, my lords, I have pointed discrepancies in the proceedings with respect to data of water being used for the drinking purposes, my lords. And I've also shown you the documents that till today, the revised administrative sanctions also provide the dam for irrigation, my lords. My lords may also see the same reply.
You are using for drinking water. What is that? That is the controls. How can we decide those?
About 21.
My lords, it only shows for the drinking purpose
Prohibiting
in
the
data.
industrial irrigation. So anything to be argued further? Or we kept?
Lords, I only want to show that in page 3, para 5, my lords, they reply the statement of objection in the state, my lords. My lords may please note few lines in the reply.
Paragraph?
My lords, para 5, page 3.
Paragraph 5, page 3.
Statement of objections, my lords. My lords may have
Statement
last
of-
3 lines.
Statement of objections. All.
Yes. I
Please,
filed
please,
it.
my lords. My lords may have last 3 lines as of now.
On
Standing,
page,
if my lords has on page 3, my lords, para 5.
correct. Last 3 lines.
My lords, as of now, water planning is done. TMC only, which includes
Yes, as of
Point
now.
two,
water
3, 5.
planning.
TMC for irrigation, my lords. Their own data shows that 24 TMCs for irrigation. Lords, the data discrepancies and it needs an investigation by a high power committee, my lords. And even though they show it for the drinking purpose, for drinking purpose is baseless and they are diverting water. Industries in the name of drinking purpose, that is my allegation and is not replied by the state. There are industrial areas that are fantastically performing and the water is being stopped for the irrigation purposes, which are completely, the industries are completely dependent on this reservoir. And my lords, unless there is a retired judge of this honorable court, my lords, in the committee for the investigation of the purpose of use of this water, my lords, this truth is never coming to the light. And my lords, I have shown in their administrative sanctions as well. And my lords, the respondent number 2, regional commissioner, has no authority under any law to stop water for the irrigation. Without being any authority, he decides when to stop the water, when to supply the water. They only use the penal provisions of the Irrigation Act, my lords. They do not recognize that the farmers have a statutory right under the Act for the irrigation water. Lords, my allegations of industrial use are not applied by the state, my lords. And it is neither denied that the industrial areas are functioning while the water for irrigation is stopped.
My lord, I have met that contention in paragraph 14 of my statement of objections, page 7, second sentence.
So they want, petitioner want the water to be used for what purpose?
Drinking purposes, we have said we have taken into consideration all aspects.
If I may reply, my lords, we have no objection if the water is being purely used for drinking purposes, my lords. Our great concern is in the name of drinking purposes, they are diverting the water to industries. That is my allegation, my lords. Even within the city limits of Hubli and Dharwad, my lords, there are a number of industries, and the data shows that zero water for industries, my lords, not even a single drop. And that is how these authorities are manipulating the data to oust the right of farmers.
Or learned, the.
My lord, can I
Right.
make one submission? Paragraph 14, my lord, second sentence. I have clarified the doubt. My lord, with regard to formation of the committee, I have also produced the government order at annexure R3.
That's even on the last day, I have stated the committee which is being formed is a statutory committee, and the committee I am seeking is for
No,
pure
let the
purpose
coun-
of investigation.
Let the government council submit, yes.
Please,
If you
please.
need be, you submit it, submit in the agenda, yes. Yes.
My lord, that's my submission, my lord, paragraph 14. And second sentence in paragraph 14.
What is R3?
My lord, that is the committee, government order for formation of the committee for releasing the water for irrigation and for drinking water purposes.
Heard learned advocate, Mr. Person, what is? Sanket for the petitioner.
Lords.
While this petition was earlier argued by the respective council for the parties and the pleadings were also completed, today when it came up for further consideration from a learned advocate, Mr. So-and-so for the petitioner, made these elaborate submissions. Made his submissions to video conferencing inter-alia to highlight the amendments in paragraph 5, in particular last 5 lines from the evident reply of the respondent. Learned additional government advocate Srimati Nilofer Akbar. Don't write that. Or learned advocate so and so for the petitioner. While the present petition was argued by learned parties earlier, from when it came up today for consideration, from a learned advocate for the petitioner appeared through video conferencing and made his submissions. Paragraph. Heard learned advocate Mr. So and so for the petitioner and learned additional government advocate Srimati Nilofer Akbar for the respondent state and his authorities from at length. Party stated, learned advocate for the party stated that they argued the petition finally. They further stated that the pleadings are complete and no further are required to be added or supplemented. Resort for judgment.
Obliged, my lord.
My lords, my one last prayer would be, my
Yes.
lords, to form a committee, my lords, may please consider the name of the petitioner so that there would be a representation by formers, my lords, in the committee. That's
Pardon?
my last prayer.
Pardon?
Lords, if my lords are convinced to form a committee for investigation, my lords may
We-
have the
we
name of
don't
the
know.
petitioner so
We-
that
Right
in
now
case,
we
my lords,
don't-
my lord,
Right now, we also don't know what view will take. Therefore, it is reserved. to
that's
you.
that would name of the petitioner. Please, my lords, in case it is convinced, my lords may have the name of petitioner so that the formers will be represented in the committee. That's my request. I am very grateful for the opportunity, my lords.
We don't know, Mr. Council, what we'll do. So any request today? is
I'm
enough.
I'm grateful, my lords, and I'm also thankful to my learned friends for the cooperation. I'm grateful, obliged.
No, I am appearing for respondent number 4, my lord.
For-
We are,
Who is, give the.
we are executing the order of the government, my lord. That, based on the committee's decision, my lord, we are releasing the water. That is our submission.
Number 30, to Viray Harassment.
For the petition.
I'm appearing
Lord,
for
the
pleading application.
impleading application filed by the one Sri B.V. Uttana Padaraj, Lord, is not the necessary party to this writ petition, Lord. I will file the objection.
My lord,
My lord, prayer is
party-
very simple, my lord.
Lord, I am the party in earlier round of litigation, my lord. Annexure W, page 165. I am the party, my lord. And the petitioner is claiming the property belongs to the impleading applicant. So I am the necessary party, my lord.
No, what is this matter?
Now, the petitioner is claiming 2 acres of property for construction of crematorium, my lord, which belongs to the impleading applicant. And I have not been arrayed as a party.
Hmm.
The property belongs to the impleading applicant, my lord.
The representation, my
We'll
lord.
take up after. There is no urgency. Send out to 10th March.
Any earlier date, my lord?
Not possible. There is no urgency in this.
Number 31, Let's appear for the petitioners council in this case. The matter relates to the caste census undertaken by the government of Karnataka in the years 2014 and 15.
Go after vacation. What is it?
Matters may have to be heard. Finally, that's what my lords also were pleased to express their opinion on the previous hearing.
Caste census.
Caste census, please, my lords.
I appear for the state commission. It is not a case of caste census, but a case of socio-educational survey.
Whatever it is, but after vacation. 24th, 25th February.
That's one submission in this. State has filed a affidavit stating that, my lords, it's the census started, my lords, the order was passed in 2014. My lords, the census according to them itself, my lords, as per the affidavit filed by them, was conducted, my lords, from 11/4/2015 to 35/2015. My lords, now after almost 10 years, my lords, now it's over. My lords, till then, my lords, the status quo may be maintained. I'm not asking for any of the indulgence, my lords. My lords, since the 10 years is already over.
Without
as per
hearing,
the-
no, just next.
Number 32.
Much
Date.
obliged.
Any date, my lord?
Already given.
Number 32. To Ravi Shankar K.
My lords, serial number 31 and 32 is the same identical matter, my lord. I request to connect both the matters along. It is also,
It's the same as 32, 31.
yes, my lords, can be heard together, my lord. Please connect the matter along with the serial number
Send
31.
out to 25th. We will not connect unless we hear it. 25th of February.
Number 33. Anif.
I appeal for the petitioner, my lordship. There is some measurement taken by this. I learned that there is some measurement is taken by the 6th respondent, 5 and 6 respondent with respect of the encroachment of the land.
My lord, it's a Tumkur City Corporation who will have to,
No, Bellary.
I'm sorry, the Ballari, my lord. Commissioner Ballari City Corporation has to remove the encroachment.
You approach Mr. Council. It is may approach them. What is there to? entertain here. Encroachment.
You already approached the commissioner, my lordship. They are not taken any action.
Who appears? Nobody is there.
My lord, Mr. Sarthi.
So learned,
We are
presence of
Sarthi.
learned counsel for the respondent was awaited. In when stand over to 26th of February. Yes, next.
Established.
Number 34, Avinash Gowda.
Petitioner, madam, press time. Press time, madam.
Time after vacation.
Well.
10th March, as requested by learned editor.
Number 35, disposed. Number 36, Srimati Vaishali Hegde.
Lord, appearing for the respondent, my lord, in this. In fact, there are three petitions, my lord.
The first of the writ appeals, Your Lordship, I appear for the appellant. This may not survive for consideration because the writ appeal was filed on a limited ground that these are petitions arising under the POSH Act against orders passed under the POSH Act, directing that the respondent be reinstated to his original position. That part of the order was stayed. The inquiry has been conducted and the order has been now challenged in the writ petition at 36.2. So the writ appeal, first of the writ appeals, 1189 will not survive, Your Lordship,
1189.
of 2023.
Will record your state.
Please.
Learned editor Ms. Vaishali Hegde stated that any of the subsequent developments.
Yes.
Writ appeal number 1189 of 23 would not survive. Full stop. Accordingly, the said writ appeal is disposed of as not surviving.
Please. The contempt, of course, my learned friend is there. The contempt also will not survive because he has challenged that order. He had filed the contempt because an order was not passed.
Contempt, all contempt will not survive.
Discontempt, contempt 10876, 1076 of
Separate
2023.
order in 10, contempt petition 107.
Contempt, my lord, may be kept open for the reason that the order was very specific, stating that all the payments that was pending to be paid to the petitioner in WP had to be paid, which until this date has not been paid. So the contempt can be kept open, my lord. It can be taken up and heard on another date as well, my lord. As far as the writ petition is concerned, since the writ appeal does not survive, the writ petition is supposed to be now sent back, my lord, to the single judge. But the contempt survives, my lord, for the reason that the order that was initially passed was to make sure that all the backlogs were also paid, which is until this date has not
Why
been.
writ petition should be sent back?
Yes, what happened? The learned single judge referred the matter to the bench because these matters were pending. Now, because I state that these.
Because the appeal was pending, my lord, it was sent here to be tagged. Since the appeal does not survive, my lord.
Writ petition number 4649 of 24.
Yes, ma'am.
Full stop. Straight order.
The petitioner, Your Lordship, is a professor. The charges against him are harassment of a
It was in
student.
light of order dated 27/6/24 passed by learned single judge that the present writ petition, that the caption writ petition came to be tagged to be listed with writ appeal number 1189/23. Full stop. As per the order passed today, writ appeal number 1189/23 has been disposed of as not surviving. In that view, the present writ petition shall now be listed before the learned single judge as per the roster.
Please. Let me help you, sir.
What about contempt will not survive?
Contempt will survive, my lord. I will argue on that, my lord. I'll physically be present to argue that, my lord.
All right.
Contempt. The
What is the
contempt, Your Lordship may kindly see, is against the earlier order passed by the learned single judge. Now, thereafter, the fresh order of inquiry has been.
Correct. So will not serve.
And then, now he has challenged that, but he wants the contempt on the earlier case to go on.
I will be physically present, my lord. I'll explain that, my lord. That may be taken up post vacation, my lord, the contempt.
Contempt. What is the directive?
Yes, my lord.
The learned then
Your Lordship may kindly see the order of the learned single judge is at page 9.
The
Page-
appeal arose from this very order,
Please, Your Lordship,
read appeal which is
was against this order,
against this.
was very same order, but to the limited extent that he be regarding para 4, in my view, this submission cannot be accepted since the order passed by this court was unequivocal, and it was stated that he would be entitled to all consequential benefits, and one of the consequence was the restoration of the post he held on the day of punishment. As a consequence, a direction has to be issued to the respondent to grant all consequential benefits to the petitioner, which arose by virtue of quashing of the order dated so and so, including restoring his position. Now, I was aggrieved by this, and that is why I approached this honorable court in writ appeal.
Press inquiry is held and
Inquiry has been held and a fresh order has been passed.
what order is passed?
Order has been passed stating that 2 increments are withheld, plus he has not been demoted, but he cannot be in the teaching faculty of the university because of his conduct.
Now, my lord, that order that I had approached before the Honorable High Court, my lord, in WP was in order to give effect to the order passed in WP number 204394 of 2018, which was in the year 2023.
Mr. Counsel, in view of the subsequent development, nothing will survive. This contempt petition arose out of order dated 24 January 23, passed in the writ petition number 204394 of 2018. The challenge in the said writ petition was against the order of penalty dated 21/4/18. In the final analysis, a single judge held that the disciplinary inquiry pursuant to which the penalty was imposed was against the well-settled principles of law governing the disciplinary inquiry. In that light, order dated 21/4/18 imposing penalty was set aside and the petition was allowed. Paragraph. However, while allowing the petition, a single judge observed in paragraph 15 that the respondent university shall be at liberty to initiate inquiry against the petitioner in accordance with law after following all the procedure and pass approved order in accordance with law. Paragraph. When the contempt petition came up for consideration today, while the assertion of learned advocate Mr. So and so for the complainant is that the contempt petition would contempt of the court, allegation of contempt of court would survive from a learned advocate Ms. Vaishali Hegde for the respondent university stated that in view of the permission and the direction given by learned single judge, university proceeded against the petitioner complainant with a fresh inquiry. Full stop. It is further stated that the fresh inquiry has been concluded and the penalty of withholding of 2 increments is also imposed. It is further stated that the petitioner is not to be retained in the teaching branch in light of the conduct, his conduct. Full stop. In view of the above subsequent developments, this is challenged.
And the same is challenged in the writ petition which your lordship is sending back to the learned single judge. So if he succeeds there, anyway, I'll have to think.
Not only that, the above penalty order passed afresh is challenged in a writ petition number
4649. 4649.
4649 of 2024.
Please, your
Full
lordship.
stop. In view of the subsequent developments and the aforesaid facts which are undisputed, the contempt precedent, so contempt petition will not survive. It cannot be said that any of the respondents have committed contempt of the court, much less willful contempt. Full stop. Accordingly, the proceedings are closed. The petition is disposed.
Much obliged.
Yes.
Number 37.
I'm appearing by the appellant, my lord. In this case, my lord, learned single is dismissed the petition, my lord, in the only 2 grounds, my lord. One is, my lord, selection process is
There
completed.
is a delay of 48 days.
My lord, after that, the writ petition has been dismissed, my lord. I have filed the writ appeal, my lord. Later, my lord, this honorable court is directed to file the alternative remedy, my lord, review petition. I have filed the review petition, my lord. After that, I have filed the writ appeal, my lord. This is the 4th time I am filing, my lord. That order may be taken, my lord. The writ appeal order is in page number 130, my lord.
No, what about delay?
Delay, my lord, I have filed the review petition, then I have,
Like that, where are those reasons?
please, my lord.
Where are the reasons explaining delay of 448 days?
I have filed the IA for the delay application, my lord. There are two reasons, my lord. One, I have filed the writ appeal and
Where are
withdrawn.
they? Where is that your
The
affidavit?
page number 99 is the delay application, my lord. 96, my lord. Page number, apology, my lord. Page number 96, the delay application, my lord. There are 448 days delay, my lord. There is a miscommunication with the writ petition advocate with the appellant, my lord. Then there is no information. Then when she comes to know, my lord, then she filed the writ appeal immediately, my lord. Her first writ appeal order is page number 130, my lord. In that appeal, my lord, there is a liberty to file a writ appeal if review petition is not succeed, my lord, the alternative remedy. Page number 131 is the opposite order, my lord, by this honorable court, my lord. Writ appeal number 1064 of 2023, my lord. Page number 130. 131 is the order, my lord. May I read, my lord?
There is a delay of 440 days in preparing the writ appeal. Interim application number 2 of 24 is filed by the applicant saying to ponder on the delay. Paragraph. In the accompanying affidavit, reasons are sought to be spelled out to explain the delay. Paragraph. The reasons extracted, continue. The reasons extracted from paragraph 3, which are the only reasons, 3 days and that. Then paragraph 3, I was not aware of the order. From starting to that, delay has occurred. So full stop. The above averments does not satisfactorily explain the passage of long time of 448 days. Full stop. As presently given, the reasons do not constitute sufficient cause. However, it is permissible for the applicant appellant, if so advised, to file a further affidavit explaining the passage of time satisfactorily, leading to delay of 448 days.
I'll file my fresh application, my lord, for the delay. Until my lord is permitted to,
We do not know fresh or additional or whatever.
my lord, I'll file my application, my lord. I'll file my application one more time, my lord, since it is a good case, my lord, since the selection process is still going on.
File fresh or you add or you supplement, we do.
This is application, my lord, which if we have filed in the first writ appeal, my lord, the same has been replaced by my colleague, my lord. If my lord's permits, then I'll file my fresh application for the delay, my lord. Here there is a 130 page number, my lord. This my honorable court itself is allowed the writ appeal and liberty has been given to come back after alternative remedy, my lord.
To file further pleadings, then we'll
Please.
extend over to 11th March. As per.
This seal number 38, the Shrikara PK. What's appearing for the appellant? The appellant has passed away on 15th of November, my lords. We have filed an application IA number 9 of 24 to bring the legal heirs of the appellant on record.
The appellant is R7 and R9.
The appellant is no more, my lords. He has passed away on 15th of November. We have filed IA number 9 of 2024 to bring the legal heirs on record.
9 of 24.
Please, my lords.
So to be granted.
We have no objection to that application. Only endure is, we are the subsequent allottees of the notification, where the honorable single judge has upheld the notification because this was the second round of litigation challenging the same notification. Earlier, the same notification.
Land is granted.
No, this is land which was acquired. The acquisition notification is challenged by them. Learned single judge not holds that possession also has been taken, and therefore the question of challenge can't arise. As a matter of fact, a large portion of the land has gone to the forest department. A very small portion is left, which, my lord, in any event has now been allotted to various parties. That one challenge, my lord, is now before this court. Then the landlord which has gone to the forest department, there is some other proceedings pending by them. In all of this, my lord, the learned single judge holds that possession has been taken, the acquisition is completed, and therefore there is no question of interfering with this acquisition of the BDA.
My lords, it was not only the acquisition that was challenged.
We grant your application 9 of 24.
Please, my lords.
It's connected matter application. The connected with the appeal, we filed an application to bring the appellant
no,
to R7 and R9.
So for that purpose, today 9. So in 38.1 also there is an application.
Maybe make us, may be permitted to make a submission in that connected writ appeal. You know. That writ appealer claims to be an agreement holder against the original writ appealer in the main petition. And that person does not have any interest. If he has any interest, it is an intra-se interest with respect to sale agreement of the notified property.
Between the appellant and myself.
So until and unless the first writ appeal has got some survivance out to be considered, the connected writ appeal, there's no notice also issued. Initially, they filed an impleading application before your lordships. That impleading application came to be rejected. Then unilaterally, they file a writ appeal. Try to connecting. No, whatever it is withdrawn, they withdraw it after objections are filed.
We'll see when we take up the amendment.
We are waiting from quite a long time. We are not able to enjoy the fruits of our allotment, your lord. And we are all senior citizens. We are all senior citizens.
My lords.
Vacation is not too long.
No, immediately any date.
When do you need it? You choose your date and give.
I would be anxious enough to have it on 6th, the opening day itself. I'll leave it to your lordships.
Not 16th,
Obligement.
16 January.
Obligement.
So this is a second round of notification being set aside, but still we are not able to enjoy. That's the only endure.
My lords, in fact.
Upheld. Notification is upheld. Sorry, I'll take back. Notification is upheld, even for the second time in the second round of litigation by the same writ petitioner.
See on.
Deeply obliged.
That's the IA and the connected matter media. Please,
Connected matter you want to place together. You want connected matter to be placed together. All will go then.
Number 39. The Dayanand Patil.
I appear for the respondent number 1, contesting respondent. That in this matter is service of senior counsel is engaged. After vacation it may.
No problem. I have no problem.
When shall we keep?
But sometime in January, my lord, because the
January. 27 January.
result on. This is number 40. The Rashekar.
I appear for appellant, my lords, in
writ appeals and my lords respondent accused in the contempt proceedings. Lords, in serial number 40.6, my lords, I need 3 weeks time to take steps in respect of deceased, my lords, R2. 40.6, my lords. And insofar as, my lords, so the office objections in serial number 40.4 and 40.5 is concerned, my lords, the appellant number 1 and 2 have to execute the wakalat. This is the office note, my lords.
My lord, last,
No, no.
last occasion when the matter was listed before your lordship, a small point is involved. That's what I submitted. Your lordship said in that case, we can dispose it off. That is why it was fixed today, my lord. It's a very, very small point is involved, whether they are government servants or not. That is all the point is involved.
That's a very big, after when.
Please.
Yes, one little bit. Some date may be fixed, my lord, because 2 have retired, 1 has died, my lord. If some date can be fixed in the second week also, my lord.
We'll fix someday.
Please.
And one more submission, one more contempt has to be connected, which is left out, my lord. Contempt of 478 of 24, my lord.
So to be listed with contempt it is in 478 of.
24. Obliged.
Please.
Number 41. Number 41, Mr. T.P. Muthan.
I appear for the appellant, my lord. This is the matter pertaining to the disciplinary matter, my lord. And this, the respondent was for committing serious misconduct, he was dismissed from service of the bank. And he sanctioned 326 tractor loan. And tractor loan for sanctioning also, as per the normal procedure, they have to take the opinion from the panel advocate. And this respondent took the opinion from the other persons who are not the advocates, and he sanctioned loan, my lord. And then after some time, my lord, that bank came to know that this person is sanctioning irregular tractor loans. Then they instructed him not to sanction. After getting the instruction also, he sanctioned 185 loans, my lord. And he has caused the loss to the extent of 9.18 crores. And my lord, this learned single judge, my lord, this person was dismissed from the service of the bank, and the other single judge modified the punishment to compulsory retirement. Against that only, against that modification of punishment, this appeal has been filed, my lord. And this Honorable Supreme Apex Court repeatedly passed the orders, my lord, that wherever the punishment, that disciplinary authority has imposed the punishment or appellate authority, on the sympathetic ground, that punishment should not be modified to compulsory retirement. After its dismissal, all terminal benefits, everything has been settled, my lord.
You are for Canara Bank.
Yes, ma'am.
So what are the charge? Manager, general manager. Charge sheet is late. Sanctioning 272 tractor loans. So he was dismissed. He was dismissed.
Yes, ma'am, dismissed from service, my lord, manager.
The charge which the charge is the respondent bank manager, respondent general manager faced in the department inquiry was that he sanctioned 272 tractor loans in the year 2005-06, but without conducting any inspection, and that the loans were granted to the applicants beyond 16 kilometers radius without prior permission. Inquiry was held and order dated 24/11/2007 was passed, dismissing the imposing punishment of dismissal on the petitioner. Full stop. This order, the said order was challenged before learned single judge. Full stop. Learned single judge. He is in service now,
No, my lord, dismissed
Yes,
long back,
ma'am.
my lord, 2007.
retired.
2007, he was dismissed from service bank,
No, no, he's not back pursuant to this.
my lord.
Pursuant to this,
No, he was dismissed.
what is the substitution?
No, my lord,
Compulsory retire,
the dismissal, dismissal, punishment dismissal has been,
Kelly, what did you write? Little louder. Said order was challenged before learned single judge. Learned single judge interfered with the punishment and has substituted the same.
to compulsory retirement.
By imposing punishment of compulsory retirement. Whether the punishment paragraph was proportionate to the misconduct committed and proved or not is the moot question to be addressed in the appeal. Appeal is admitted, it shall be listed for final hearing in the week beginning from 14th April.
I requested stay, my lord.
What stay?
Stay.
And he is not there.
He is not there, yes, my lord.
So then judgment and order of learned single shall remain state.
Yes.
State.
Number 42, state appeal.
Complainant in the contempt, not respond in the writ appeal.
Lord, page 18 is the impugned judgment, my lord, by which the learned single judge, my lord, has passed an order directing the respondent state to conduct
Your
Kodi and
contempt.
Durasti, my lord.
This is contempt.
Contempt, my lord, is the first petition. After we filed the contempt, my lord, and notice is served on them, then they filed the writ appeal challenging the order.
Which order is challenged?
21st September 23.
21st September.
Page 11 of the contempt petition.
So there is a sketch, there is a report of the Taluka survey. And the revenue entry, nature of revenue. Why
Revenue-
should you not conduct?
My lord, the revenue entries have been carried out, my lord, no doubt, my lord. The genuineness and validity of the grant has also proceedings were initiated and achieved finality, my lord. Here, my lord, the direction is to conduct the Podi and Durasti, my lord. The land in question, my lord, total extent was about 11 acres of land. Now, my lord, after the surveyors went to the spot, my lord, it was realized that the land is a hillock and rock, my lord, which, along with the statement of objections. The photographs have also been placed before the court, my lord.
But I'm the owner of the land to conduct voting.
No.
I'm
my
My ownership, my lord, can't be
my lord.
disputed. Today, my lord, they practically tried to undo all of that. The objections taken are, my lord, that I'm not the owner of the land. 3 times, my lord, I've been subjected to proceedings under 136(3). And every single time it has been ultimately held that there's no truth in their allegations. I can't be vexed, a citizen can't be vexed continuously by the state in this particular fashion. Even now you're saying it's in the field on the one of the ಯಾವ್ದ್ರಲ್ಲಿ previous contempt.
So page 179 of your objections filed in the event petition.
Please. Please, my lord.
You said you are taking steps to consider the prayer of the petitioner.
As a matter of fact, my lord, in the earlier contempt proceedings, they said everything is completed. It is only awaiting the signature of the DC. If your lordships kindly notice that, annexure G to the contempt petition.
That is an earlier petition.
In the earlier petition, when an order was granted,
It's 3-1, what is that?
yes, my lord. In 31896 of 2019. And then we filed a contempt.
31896.
Yes. There an order has been passed, my lord, setting aside the order where they cancelled the grant and said you're the grantee and that could not have been cancelled. Then again, when I see the writ appeal, my lord, in the writ appeal, again the same ground is taken that you're not the owner. The grant has been given by fraud. And please see annexure G, the affidavit filed last time before this honorable court by, my lord, the Tashildar. Please see page 50, my lord, in the contempt, para 2. And now a completely contrary stand is taken. Page 50, 50, my lord. It starts at page 49. At page 50.
This some other petition.
No, my lord. In the earlier petition, when they did not comply, I filed a contempt.
Same petitions, 7880.
I'm sorry. In CC.
49 is the same petition from which the appeal arises.
Yes, my lord. No, in the contempt petition, I filed the earlier affidavit. I had filed a contempt earlier for not complying with the directions. The affidavit specifically says that I have approved the POD and it is awaiting signature of the DC.
Where is they have said?
Page 50, my lord, of the contempt petition of my contempt. Para 2. I'm sorry, in the contempt petition. Para 2. I most respectfully submit that in compliance with the order passed by this Honorable Court in writ petition 31896 of 2019, dated 39. May I just read that one? I most respectfully submit that in compliance with the order passed with this honorable court in writ petition number 31896, dated 39/2020, I have issued an endorsement dated 5/3/22, as per which I have specifically stated that I have approved the Podi and Durst as per the directions issued by this honorable court. The copy of the endorsement issued by me by approving the Podi and Durst produced an annexure JKL to the writ petition. In view of my approval, the Podi and Durst work in accordance with the directions issued by this honorable court, I have complied the order. Copy of the endorsement issued by me is produced as annexure R1. Copy of sketch prepared by a Taluka surveyor and approved by me as per directions issued by this honorable court is produced herewith as annexure R2. I most respectfully submit that there is some delay in complying with the orders passed with the court. Said delay is primarily because of COVID-19 pandemic and also because of various other proceedings which are pending in respect of the same land. Proceedings initiated under section 67 is presently pending before Deputy Commissioner in RRT number so-and-so. Then he says, I most respectfully submit that there was some confusion regarding pending proceedings. I had to take legal opinion from the office of DC. Some time was lost due to administrative exigencies. Delay causes not intentional due to the aforesaid reason. Then this proceeding was closed by this honorable court because of this affidavit filed. Then they don't comply with it. I then file another writ petition then before this honorable court saying the present one. In the present one, my lord, they try to undo everything under the sun.
My lord, the affidavit that my learned friend read, my lord, is from the Tahsildar, my lord. There are two stages here, my lord. The first part is done by the Tahsildar, followed up by the Deputy Director of Land Records, my lord, who would complete the process of Podi and Durasti work, my lord. Here we commence the work, my lord. We want to give effect to Podi and Durasti. It is not that we want to shy away from this. He started the process, my lord. An inspection was done, my lord. It is an hillock and rock, my lord, not an agricultural land, not a cultivatable land. Lordship may kindly see one photographs which we have placed along with statement of objection, my lord. The nature of the land, my lord, page 185, annexure R3 and onwards, my lord, photographs may kindly be seen. The nature of land is forthcoming there, my lord.
So Podi is not conducted.
It is,
My lord, it is not approved finally.
beg your pardon?
It appears to have been not conducted.
My lord, Podi was conducted. I have the sketch as well, which is at annexure C to the contempt petition.
Must have been conducted.
My
because
lord,
sketch-
it was conducted at the.
Sketch is on record.
My
But
lord,
there's
sketch is on
nothing
record,
but
my
a
lord.
mechanism, my lord, to trouble the citizen. There's nothing else. And for reasons, my lord, which are extraneous. Continuously, my lord, how many times? Thrice.
My lord,
The area is hilly or
Doesn't matter.
Podi is not conducted.
It is
no, my
conducted.
lord,
How many
the-
hilly areas
I'll
conducted
explain, my
Podi?
lord. The sketch was done, my lord, out of total 11 acres of land, my lord. And survey was done, 4 acres belonging to them has been identified here. Now the next comes the Podi and Durasti is bifurcation and fixation of the boundary here, my lord. That is where the practical difficulty of complying with the order of the learned single judge, my lord. Otherwise, we have no difficulty. Lordship may kindly see the photographs, my lord. It's a rocky region, my lord. It can't be bifurcated and subnumber can be given to the land.
No, writ appeal is dismissed and in contempt time to comply is granted 4 weeks time.
Very well.
Your Lordship. But the practical difficulty
it's-
is only one
as a-
request, my lord. Otherwise, it is not that we don't want to do, my
We
lord.
might-
It's a hillock,
might-
my lord.
We might dictate in the open court only, in second,
Value to law.
subject to availability of time. But it is disposed.
Great.
This was which? 41.
Hearing for the appellant in this case, my serial number 43.
This was 42. 42, 40.1, 42, both. Now 40,
Serial number
43 is a-
43, I appear for the appellant's counsel, my lords.
Hmm.
Lords, scope of the writ appeal is very narrow, my lords. Now, when I'm a landowner, at the time, after completing construction in pursuant to a joint development agreement, I apply for an occupancy certificate. At that stage, my lords, I am served with a notice which my lords will find at page 138. my lords. Now, my lords will find serial numbers 1 to 6, I have no problem with. I had paid them, there's no issue. Serial numbers 7 to 20 are under the category of, my lords may kindly note, pro rata charges. And then there is some other charges and serial numbers 21 to 31. Now, I challenged both these levies before the learned single judge. As far as pro rata charges is concerned, my lords, my specific contention was this, that
pro rata charges are being levied for supply of water and sanitary connection. Under your own regulations, I have to set up a sewage treatment plant. I'm not even connected to the main sanitary line. Therefore, the element of quid pro quo itself is missing. Therefore, my lords, I'm not required to pay pro rata charges insofar as sanitary connection is concerned. So I filed a writ petition on those grounds. There was an interim order operating in my favor during the pendency of the writ petition. I should also inform my lords that
Today there is a delay of 152 days.
that's right. But there is a delay. Of course, if I'm not mistaken, notice was issued. Mr. Monesh had appeared. Correct. I'll just explain that. Can I just explain?
Pro rata, the payment of pro rata is upheld.
No delay to be gone down.
I leave it to my lords.
The delay is because we have a review petition filed. Now, I'll explain why the review petition had to be filed. My learned friend is absolutely right. There was a challenge to advanced pro rata charges.
Which was probable pro rata.
Probable, sorry. I'm sorry. APP charges. I'm not aggrieved by APP. Which is why I filed a review petition before the learned single judge, specifically contending that your lordships have upheld the levy of APP. I have challenged pro rata, which is subsequent to completion of construction. And my limited ground is this, that as far as water is concerned, I'm willing to pay 50%. In fact, the demand seems to be about 92 lakhs. I'll pay 46 lakhs. But the immediate urgency is this, if my lords, just one last submission, page 217, if my lords were to kindly see. Page 217, along with my IA. I've been served with a notice threatening to cut off water connection. My lords may make that, may state that subject to myself paying 50% of the pro rata charges. That I'm willing to pay.
That's pro rata is upheld, please, my lords, at the hands of
advance is upheld.
No, my lords, I will explain, please, my lords, what transpires, my lords. But at the stage of construction, please, my lords, we will not know what extent of the building would be constructed, my lords. At that stage, we will only demand about 15%, please, my lords, which is termed as advanced probable pro rata. Lords, when they come up with the occupancy certificate, lords, when they try to occupy the building, please, lords, the entire balance portion of the pro rata is demanded, please. If that is not paid, please, lords, then we will not be even be able to function also, please. Pro rata is upheld, please, lords, by coordinate bench of this honorable court, please.
Not coordinate by a learned single judge, advanced pro rata. All I'm submitting is this one. I'm not using their connection. And that was not considered by the learned single judge.
UP Jal Vibhag, the Honorable Apex Court has clarified, please, my lord.
That is extraneous. I'm sorry.
Your premises is present, please, my lords, in the notified area, you'll have to pay.
You discuss it.
Against that order, we have also preferred a writ appeal, please, my lords, where the BCC charges not been dismissed.
The order in IA number 1 of, it is 1 of 24, heard learned counsel for the respective parties. The present application is filed for continuance delay of 152 days, which has taken place in preparing the present writ appeal. First of the accompanying affidavit spells out the reasons because of which the delay to the above extent occurred.
First stage. What did I do?
According to the petitioner, for time elapsed leading to the delay to the aforesaid extent, as the applicant appellant was advised to prefer review application, which was review petition number 273/2024. According to the applicant appellant, learned single judge committed an error in allowing writ petition number 17084/2022 on the basis of the decision in another writ petition number 20016 of 2021. Insofar as the pro rata charges, insofar as it relates to pro rata charges, it is the say of the paragraph. The applicant that both the writ petitions stand on a different footing to address the controversy. Full stop. It is stated that review petition came to be dismissed on 24/7/2004. Thereafter, the certified copy was applied and the present appeal is preferred. Full stop. The court is inclined to accept the explanation in as much as the applicant was prosecuting the review application, in which process the delay has taken place. The reasons could be said to be bona fide. No element of negligence could be attributed. Sufficient cause is made of delay is gone. This can go after it.
Melod, may kindly consider staying that
No, Melod,
notice,
no,
Melod. Melod, may kindly see, just, may I
Pro
complete?
rata is upheld, please. Pro rata, please.
I don't know why my learned friend is interrupting me. I want to
Sorry.
explain, I want to just make across one point. If my lord saw the demand note, the demand note is in two parts. One part was struck down in the same judgment my learned friend is referring to. Pro rata charges, my lords, was never under challenge. It was advanced probable pro rata charges under challenge. Now, my specific contention is this. I am not using the BWSSB sanitary connection, but I am using your water connection. So therefore, out of a demand of 92 lakhs, I'm making a statement that I will deposit 50%. But please don't cut off my water connection because there are 160 units. That's all my limited price. 50% I will deposit. I'll pay with the contesting.
They are disconnecting the water connection.
I'm sorry, my lord.
They are disrupting the water connection.
They have threatened to, if my lords were to kindly see, which is why I was drawing my lord's attention to page 217, which is along with my IA number 3.
Number 3.
Yes, my lords. Page, running page 217.
Running page 217.
Along with the IA number 3 for production of documents, because this happened post dismissal of my review petition.
Where is that?
It's an intimation letter dated 13/5/24.
Same.
Kindly see the last paragraph there, my lords. Further, you're hereby directed to pay the charges which were not paid within a period of 7 days. Treat this utmost urgency and make an application, else the water connection will be dismissed.
So what are the charges they are asking for? On pro rata?
As of now, only pro rata charges, because the other charge was struck down.
Something like this, my lords, if it is within the
The
code.
water charge.
I'm sorry, what?
Pro rata.
Pro rata charges. Pro rata charges is what is being.
Water charge.
Yes, madam. For water and sanitary, insofar as water I'm willing to pay, which works out to 50%.
Let's, may I only submit, please, my lords?
One second, let us understand the complaint.
Kindly see, my lords, if my lords were to come back to page 138, which was the impugned demand,
128.
138.
138.
That's right.
About midway through the page, your lordships will find pro rata charge running from serial number 7 to 20.
11 crore,
I'm sorry, what?
total is 11 crore.
No, my lords, on page 139 towards the top, my lords will find 92 lakhs 40,542. The other charges are not an issue, my lords. I'm only concerned with the pro rata charges. And all along, while the writ petition was pending, my lords, I had the benefit of an absolute interim order. Here I'm depositing 50%.
This beneficiary capital contribution.
That was struck down, my lords. That
That
is
is- that
struck
is-
down by the.
That was struck down.
That
We have
is in
preferred an
appeal
appeal.
before your lordships.
That is pro rata.
Pro rata was never an issue, my lords, according to me. Advance pro rata was an issue.
Submit, my lords. May I
And
submit?
my lords will find GBWASP and BCC, that was struck down by the, BCC was struck down by the learned single judge. And
Sir.
GBWASP as well.
You are running some industry.
No, my lords, it's a residential unit, apartment. I'm told, my lords, there are about,
Yes, what do you?
Plus, pro rata is never an issue. It is upheld at the hands of,
Examine in the.
No, my lord, can it is,
I'm sorry, my lord,
30,
please.
230.
240.
Serial number 46, my lords.
We'll sit at 240.
Serial number 46, my lords.
Yeah.
I require some time, my lords.
Okay.
It may be taken up after.
Time is granted in all matter, wherever you sit.
Please.
You keep here on. Sorry, we had a meeting. Yes, we went long. Yes, yes. Anybody?
Lordships kindly, serial number 72. Other day we argued regarding the BBMP mortgaging the land belonging to EWS matters listed today. There's an urgency, it can be taken up ahead of them. I'm not sure whether we'll have the time.
One part that is going on. The commercial appeal.
Please.
Yes.
So
If it is.
Learned
Council mentioned, my lords, I also appear. I also need some instructions, my lords. I request, my lords, that after it. Because anytime the auction can happen, my lord. At least can it be,
You can move learned vacation, Judge.
if a liberty, because during vacation they may not allow.
We are nobody to give liberty. You convince learned vacation, Judge.
My lord, that's never been the practice of this court, my lord. This time when the matter is pending, they will not do it unless it's a fresh matter, my lord.
So you can't mention before learned single.
During when the pending matter cannot be mentioned, my lord. That's a practice here, my
You can't file
lord.
IA.
Unless a leave is granted.
Can't you file IA fresh?
Unless a leave is granted, they don't entertain.
For filing IA, no leave.
Even IA, my lord, this is a practical difficulty we face, my lord. At least can be had on Friday, my lord.
So which
Friday.
form, which? Or any leave granted. In the event auction, in the event auction is announced, in the meantime, it will be permissible for this is appeal.
Yes.
Appellant to move the learned vacation.
No, this is a writ petition, man. This is a writ petition.
Permissible for the petitioner to move the learned vacation, Judge, subject to the petitioner satisfying learned vacation, Judge, about urgency.
Much
Can't-
obliged.
I can't-
matter, my lord.
It's a bench
I
matter.
can't take away the
It's a
discretion
bench
of,
matter, my lord. Comes
discretion
before-
of vacation, yes.
It comes before bench, my lord,
Division
because
bench.
there is an earlier order passed by this honorable court that all matters pertaining to this land should come only before court all one. That is one of the reason why we submitted that there's already a writ petition pending.
We have granted by judicial order, liberty. It will be posted. Liberty is granted to you to move the learned vacation bench, subject to satisfying the learned vacation bench of urgency in the event the auction is announced. That's all.
Much obliged.
One submission, my lord, serial number 5 in list number 2.
Serial
For
number?
Short accommodation, my lord.
Serial number?
5, my lord. It may be taken up immediately after vacation.
Why? Whole entire second board. After vacation.
Your lordship, least to serial number 4, your lordship.
Entire board,
Vacation.
I am for responding this serial number upper Malaship.
entire board number 2 will go after vacation.
Much obliged.
Allowed serial number,
Malaship's, my lord, Malaship's already in other cases, my lord, passed the judgment, my lord. Wherever there are more than 12 years, my lordship dismiss the grantees writ appeal, my lord.
allowed serial number.
35 years delay in my case, my lord.
Not only the advocates, but learned additional advocate general also, you also object. So partial acceptance of a request. All matters will go beyond vacation. This is all in lighter way, don't.
Excuse me. Malaship's, serial number 6, in list number 2, regarding PTCL matter, my lord.
You want to proceed?
But may I request your lordship to kindly accommodate me.
To accommodated already, all entire board is accommodated.
My lord, interim order is, has been granted in that case.
So wherever interim order will be extended.
Serial number 4, my lord, is 35 years delay is there, my lord.
No mentioning, it is already gone.
Allowed serial number 3 can be posted after vacation, my lord. Serial number 3,
No,
these
no,
two.
if you mention, it will not be posted. It is already posted. Yes.
Okay.
83 is an urgency. Urgency can be kindly be taken up.
Which one?
83.
What is that?
Education matter. The lordships had already granted an interim order pursuant to which examinations are already undertaken. Had missed one of the examinations to note the fact that the order copy was not, the matter was not considered. We are requesting for reconduct of examination. Lordships have already granted an interim order here. Other subjects we've
How-
already completed. Reconduct was permissible, my lords, and they have extended similar relief university under similar circumstances earlier. Lords may kindly consider. Because if we.
You could intimated the order was passed.
The order was passed by the learned single judge on 29th, my lords. The examination started on 2nd, but order copy was not released.
Who by us?
No, my lords, the learned single judge.
Then we granted you the relief.
On 4th, my lords, after the first examination.
There you appeared or not?
Yes, we are.
Okay.
The one that we have missed.
They have deliberately avoided service. See the notice has been dispatched. They entered the entry. How they with it. Communicating. This is dispatched from them 78. Sit examination of the same semester that they conducted. But the lunch. Even today, the service is not done. It's conducting the exam.
You took advantage of overall, benefit overall or not?
Yes.
Then now what is the difficulty?
So, looks the examinations which were conducted during that interregnum between the releasing of the order copy by the learned single judge and your lordship's order. We missed one examination. If we don't appear, my lords, in that examination, or if it's
So
not.
when that examination going to be held?
It's already conducted, my lords. On 2nd and 4th, it was conducted. Your
So
lordship granted.
we'll take a call after vacation. You show the other side. Today other side is there.
That needs to be reconducted. That's the prayer, my lords.
That will consider.
Yes.
But what is that urgency for today only take it?
That, my lords, practicals are already completed, my
So
lords.
stand out to all let, stand out to 8th of January. Before the next date, the summons, if not served, shall be served on the other side.
My lords, kindly permit me to serve it on standing council of. the-
Why you are not taking the summons?
I have already taken, my lords, notice is
Oh,
already.
belatedly it is taken.
My lords, we complied with the office objections, my lords, 2 volumes were created. After complying with the office objections, my lords, notice was taken. That's
So
all.
before the next date, well before the next date, the copy of the notice of summons shall be served on the other side.
Standing council of the respondent authorities.
No, to the parties.
And summons. Please,
And summons is, service by and summons is permitted.
please, wait. Wait.
List one, seal number 43.
Tomorrow morning it will pass.
Yes, madam.
Tomorrow.
I leave it to my lords, but a very limited aspect I was trying to say was that I'm not on the validity of the levy, but the fact that I'm not using the sanitary connection at all. So that's the gist of my argument. What happened, my lord, the learned single judge clubbed it with the main batch and disposed it off. That was my only limited, because-
That aspect has been considered, my lords.
In
My
the review
respectful
order.
Submission. My respectful submission, even that aspect has been considered.
Sanitary services.
I'll clarify that position.
Partial services will come to the water supply. That's serious. Correct. Deposit, that's what you say.
ಎಲ್ಲ ನಮ್ next ಕಡೆ sir.
ಹೌದು, ಅದು ನಮ್ದು ನಡೀತಾ ಇದೆ.
2:30 ಹೇಳಿದೆ.
ಹೌದ್ರಿ, ಅದು
This page 217 is after the order of learned single judge.
That's right, but the review order, my lord is looking at, my lord is looking at the,
Intimation letter.
yeah, that's right, that's after,
That is a consequence of your rejection of the.
correct. Which is why, my lords, your lordships may put me to terms, 50% of the pro rata charges I will deposit. Let them not,
So this appeal is against the order in IA.
I'm sorry, ma'am. No, this appeal is against the order rejecting my review petition in the writ petition. So I'm aggrieved by both the writ petition order as well as the review petition order. The review petition order, my lords will find at page 166. Operative portion will be at page 172.
But what is page 30 order?
Page, I'm sorry, ma'am,
30.
30, I'll just come to that. So page 30, yes, ma'am.
The original.
Original order, the learned single judge's order in the writ petition, aggrieved by that order on the limited aspect of the fact that I was not on the validity of the levy, which was what the larger batch had considered, but on whether I can be mulcted with the liability when I'm not using the sanitary charges. I filed a review petition. That review petition came to be disposed of, against which I'm in appeal.
Let it be tomorrow.
Very well, I'll leave it for us.
My reflection may not come in the.
No, very well.
Actually.
I would never.
Tomorrow till 11.
Serve me the copy, please, my lord.
What did you?
Kotti, 2211 we have served and
Hmm.
filed acknowledgement.
We'll
My
serve.
name may be reflected.
Today delay is content to be listed tomorrow.
My
Tomorrow.
name may be shown in the cost list. Name may be reflected in the cost.
His
list.
name may be reflected. Mr. Monesh Kumar's name may be
Registry
reflected.
shall mention the name of Mr.
KB Munish Kumar.
KB Munish Kumar as appearing for the respondent while notifying the appeal
So very appreciated.
tomorrow.
Great.
Because I understood that the demand is for the two service. Is permission to defer the home.
First four matters, list one, seal number 3. Keshav Murthy.
I appear for the complaint, my lord.
So decision is not taken.
My lord, they are not paid, my lord. They are not, this is for the equal pay for equal work.
Direction is to take
Right.
decision within 4 months.
Yes, ma'am, they have not complied the orders of this court, my lord.
Notice it on 3rd March.
Lords, we have filed our affidavit, my lords.
Will you file a
We
repeat?
have filed our affidavit.
Not received. I have not received, my lord. I have not received any affidavit copy.
Give to.
But we all services are done through email, my lords. We have given that.
Given. But he is threatening.
I'll verify, my lord, whether they have complied it or not. I will verify it, my lord, whether they have complied, they have implemented the orders of this court or not.
At the end of the board. Today at the end of the board.
After, soon after vacation.
Soon after. 16th.
This is number 9. Gauri Shankar, 14%.
Lords, this is about Section 368 of BBMP Act 2020, which mandates the formation of Grievance Authority. It's a quasi-judicial authority for handling citizen grievances. Today, we are completing 4 years after the enactment of this act, but this authority is not yet formed.
Go before them and
Sorry, my lord.
make a representation.
I already spoke with them, my lords. I spoke with the Urban Development Department Secretary also. I spoke with the Urban Development Department as well in Caste.
Speaking will not do you to give in lesson. Spoke towards means what?
I spoke. I can do that once more, my lord. I can do that once more and then approach you also, if you permit me. Because there's been a 4 years delay. That's why I've approached you.
This petition is filed by 14% by one Gauri Shankar S, who appeared as party in person. Heard learned party in person paragraph, as well as learned additional government edition, Srimati Nilo Parakko, upon service of the copy of the petition in advance. The limited grievance and cause limited grievance raised and the cause sought to be espoused by the petitioner in this petition is that under section 368 of the Bengaluru Mahanagarpalika Act 2020. There exists a provision whereby the government may, by notification in the official gazette, constitute for the corporation a grievance redressal authority consisting of the members indicated in the section. It is the case of the petitioner paragraph that the grievance redressal authority has not been constituted despite the aforesaid provision in the statute. It is submitted that if the grievance redressal authority is formed and it functions to deal with the various issues from several of the civic problems and complaints arising in the city of Bengaluru could be properly redressed to the satisfaction of the public at large. Paragraph. While noticing the case of the petitioner, it could also be seen that while noticing it could also be seen that the petitioner has already approached the Additional Chief Secretary of Government, Urban Department Development by writing a letter making representation dated 27/9/24. The letter spells out the grounds as to why the petitioner wants to get the grievance redressal authority constituted under the Act. Full stop. The said request and the representation and the request for the constitution of the authority is already pending with the authority for an appropriate decision. Paragraph. In the above circumstances, the court deems it fit to direct the respondent competent authority, respondent number 1, to consider the said representation in proper light and in accordance with law to decide on the issue expeditiously with the aforesaid observations to the present public interest petition is disposed.
Thanks, my lords. Seal number 10, Siddhanupur Vishwanath.
My lord, here the respondent number 9, my lord, proposed to retail the my lord, here the respondent number proposed to retail the petrol pump, my lord, in survey number 60 of the Turburalli village, which is, my lord, form the encroachment of the
What is this?
stormwater drain, my lord, which is annexure C, my lord. I produced the survey sketch, encroachment survey sketch, my lord. It's very clear that, my lord, southern portion of that survey number 60 clearly encroached by the respondent number 9 and set up in a petrol bunk in that location, my lord. My lord, as per annexure A, the lease deed entered between the respondent number 8 and respondent number 9, my lord. Another one violation here, my lord, it is a residential converted land, my lord. Now they are put up petrol bunk in that location, my lord.
And another violation here, my lord, within a 15 meters distance from the situated land, my lord, there is a high tension electricity line. It pass over the scheduled property. Kindly perusal the annexure F series, my lord. Photographs of produced, my lord. In southern portion of the survey number 60, there is a storm water drain. It's very clearly seen in that picture, my lord. And my lord, Annexure E, the Central Pollution Board guidelines based on that Green Bench Tribunal, my lord. As per the violation, it's very clear that, my lord, as per page number 53, Rule H, citing criteria of the retail outlets. May I read, my lord? Page number 53.
Heard learned advocate, Mr. Repeating.
Yes, my lord.
Heard learned advocate, Mr. So and so of the petitioner. And learned additional government advocate, Srimati Nilofer Akbar. For the respondent state and its authorities. Upon service of the copy of the petition in advance. The petitioner herein has filed this petition, styling as public interest litigation, stating that the petitioner is working for the cause of public. However, neither in the cause title nor in the averments, the petitioner has stated about his profession, avocation, or activities. Be as that may, paragraph. The grievance sought to be raised in this petition in the guise of public interest, under the banner of public interest, is the setting up of a retail outlet petrol pump by respondent number 8. Respondent 9. Bharat Petroleum, which is advertised for grant of dealership as per advertisement dated 28/6/23. And that respondent number 9 has applied for such dealership. It is stated that it has also obtained a letter of intent for establishing and commissioning the petrol pump public fuel station. Full stop. The petitioner has objections to the setting up of the establishment of the petrol pump. It is the case that the proposed retail outlet of petrol is going to be set up in old survey number 60, new survey number 60/4, situated at Thubarahalli village, Parthur Holy, Bangalore East. And that towards the east of the said site, a canal is passing. It is therefore sought to be submitted that the site is not feasible. Wherever it is further the case that there is an encroachment at the place. It is also the ground sought to be raised that the area, the land site where the petrol pump is going to be set up is earmarked for the specified group of housing apartments, and it is to be used for residential purpose only. With such pleadings and premise. With such pleadings, the petition is premised with such pleadings, it is prayed by the petitioner to direct that the retail outlet of petrol pump, fuel station in survey number 60/4 at the Thubarahalli village may not be permitted. It is further prayed to direct respondent 1 to 7 authorities to remove the encroachment on the land. Full stop. A fact emerges from the record and from the prayer of the petitioner itself that a lease deed dated 19/8/24 is already executed by respondent 8 in favor of respondent 9, who is given the letter of intent and who is set to establish and commission the petrol outlet. Full stop. It is to be observed that before granting such letter of intent and clearing the site for the petrol outlet, the competent authority would have examined all the aspects, including the safety aspects, as well as the issue of suitability of the site where such fuel outlet could be set up. Full stop. The map of the site is produced by the petitioner himself. Into bracket page, which is part of the lease deed. The lease deed along with the annexures of the lease deed are produced. Full stop. The map figures at page 36. In the compilation of the petition, on the record of the petition. Full stop. The situation of canal and other attendant parcels of lands are shown in the map. The site where the petrol pump is proposed to be set up is also indicated. Full stop. The court does not find any good reason when the advertisement has been issued by came to be issued by the respondent number 8, ONGC. Bharat Petroleum Corporation Limited, and that the lease is also executed in favor of the person who is granted letter of intent to start the retail outlet. Full stop. In the totality of facts, no case is made out to interfere and grant any relief in this public interest petition. Full stop. There is nothing to show that an illegality is committed in giving the land for retail outlet to respondent 9, which is in accordance with law and after undergoing the necessary procedure resulting into execution of the lease deed in favor of respondent I for the purpose. Full stop. The petition is dismissed as meritless.
Obliged.
Number 60. MS Chandrasekhar Babu.
Hearing from
Complaint.
the respondent,
Any
my lord.
urgency, then only we'll take.
Yes,
My lord, we have
Here.
what had happened? In this case, I argued the matter at length and this honorable court directed me to produce this is in respect of pensionary benefits, my lord.
We have filed our compliance, my lord. If-
Compliance was not done. That is my submission, my lords.
This is a direction.
Annexure
A at
Annexure A
page
in
11.
Read it.
17 minutes. The operative portion is at 17 page numbers.
17.
247A of CCA rules has been questioned, my lords. May I read it, my lords. As per this order, this honorable court directed me to produce the government order, my lord. I have produced the same before this.
Respondent number 4 is directed to reconsider the
Reconsider,
Yes, my lords.
and pass appropriate orders.
please. My submission, my lord, is that we have considered the representation and we have filed the endorsement of considering the representation, which I have, the Kannada version, the original version was filed on 21/2/24. And because there was no translated version of the same,
No, you have reconsidered the representation.
yes, I have.
No,
My lord,
that is
just for
not
a
so.
moment, if I may take your lordship through the endorsement that I have, Himbara that I have given the complainant. In that, we have said that, my lord, if I take your lordship through that document for a moment. It is filed on 25/10/24. Dated 19/2/24, my lord, the English translated version. 19/2/24. The last para. The last para, my lord. KS 80 original application so-and-so has now been challenged before the Honorable High Court in writ petition so-and-so by the state government. And on 2/11/23, interim stay to that K80 order has been passed. That is 3/8/2000, to the order 3/8/2017, which we were supposed to consider. Now, having said that, my lord, I'd just like to place the interim stay. So there is an endorsement in place and whatever the outcome in that writ petition, that is 2/11/43, accordingly, we will decide.
Prior to that, contempt petition has been filed, my lord.
The issue is about eligibility of
You are
the
eligible.
complainant.
As per 247A CCA rules, I am eligible, my lords. Your lordship kindly have a look.
My lord, the
No, it is not challenged. In this writ petition in 2/11/43,
stay.
It is,
interim stay is granted.
my lord, my,
How
my,
can we,
Allah,
how can
my,
we deal with the contempt?
Please.
my submission before this honorable court is that, my lords, earlier point of time, this honorable court heard the matter, my lord, and directed me to produce the government order, my lord. Two government order I have produced, my lords. And also, annexure A, your lordship kindly I'll have a look at, my lords. In page number 17, my lords, it is clearly stated that
When the vacation is nearby, vacation has 2 days.
yes, my lords, but
The principles of law
No, no.
changes.
no, what, no, my lord, what had happened earlier, it was, the matter was heard. Finality, it,
You tell me,
I-
when the vacation is nearing, the rules of law changes.
no,
So then how can we grant
no, only one point for,
what?
only one point for consideration, my lord. This honorable court heard the matter
and directed me to produce the government order. 2 government orders I have produced. And the petitioner, as per CCI rules 247A, the petitioner is entitled for pensionary benefits, my lords.
How can we deal with the order in any manner when it is stayed, on the basis of which your rights are, you are claiming right?
That is subsequent, that is my submission, my lords.
Whatever it is. at this-
Subsequent to filing of contempt petition, they have filed the,
It is of no consequence, subsequent or prior.
we will look into it.
So what do you?
Okay, sure.
My lord, my only submission is that the contempt would not lie in view of the stay order by the learned single judge, wherein
No, no,
this
subject to
order
outcome of that, we will see.
is seized. And
It be.
even on the basis of merit, even if we go into the merit, he is ineligible. And
Next.
the order says only consider the representation in accordance to the KAT order and whatever the prevailing laws. So we have considered and passed the endorsement. So the contempt does not lie.
The only direction which required to be complied with by the respondents, as issued by learned single judge in order dated 1st December 21, while disposing of the writ petition, was that he was to direct the respondent 4 to reconsider the representation and pass appropriate orders in light of the observations made in the order and keeping in view the directions issued by the tribunal in application number 569 of 20.
In that, there was a condition direction, my lords.
Dated 3/8/17. Full stop. In response to the notice received in this paragraph, contempt petition, compliance affidavit is filed, memo is filed, along with which endorsement dated 19/2/24 issued by the Tehsildar, Bangalore South Taluka, Bangalore, is produced. Copy of the endorsement is so and so is produced. Full stop. It is stated thus in the endorsement, extracting the relevant part. So this bracketed part, page 8. Full stop. Thus, it is clear that the compliance that the consideration of the representation chose to be based on, which was to be guided by the directions of the tribunal in the order in original application number 569 of 15, has been subjected to challenge in the writ petition number 21143 of 23 by the state government, and in that writ proceedings, stay order is granted against the said direction to the tribunal. Therefore, at this stage paragraph, it cannot be said that any of the respondents have committed contempt of the court, much less willful contempt. Full stop. The contempt proceeding does not survive to be considered for the present. They are disposed of. The parties shall abide by the final outcome of the proceedings of the writ petition.
Much obliged. my lord.
In the event of writ petition being dismissed, the respondent state authority shall implement the directions within 3 weeks.
Much over.
This one, still number 108. Mr. Varun S.
Third volume, I was concluding with the last submission that they made, that penalty imposed was ignored by the learned arbitrator. So we are looking at what evidence was there before the arbitrator to consider what the imposition of penalty. I was, my lord, yesterday at page 903
exhibit R72.
Page
903, volume 3, R72, and 905, R73. These two exhibits. R72, page 903, R73, page 905. Third one. Now, in R72, it's a letter of 9th March 2018. The NILET, the government department, was discussing in correspondence the imposition of penalty, and at that stage had indicated, as per the table at page 904, that if penalty were to be imposed, instead of any money being paid to the appellant would have to refund money to the government department. 1 crore 17 lakhs 70, 1 crore 11 lakhs 76,865 at page 904. If this were the final position as I was submitting yesterday, I would have had to bear 61%, 39%, both together would have to refund to the government. As it so turns out, eventually there was no refund required. If it were minus 1 crore 11 lakhs, I would have had to bear 61% of this. They would have had to bear 39% of this. This did not happen. At R73 was the subsequent correspondence of April 2018 at page 905. This is all still proposed only, my lord. There is, as I submitted, there is no evidence brought before the learned arbitrator to show that this is eventually what happened. All this is only interregnum correspondence. Page 906, my lord, shows that after the penalty was imposed, apparently of 1 crore 12 lakhs, an amount of 21 crores was available for release. And more or less, that is the amount that has been released, because 17 plus 4, 21 crores. After imposition of penalty. Therefore, my lord, and this is relevant at page 906, that last column, the number that is there, 906. The last column, net payment, my lords have that, 21 crores. Page 906.
There is no 906. There is no 906.
For this.
Yesterday it was not.
Yes, my lord, that was also missing.
Anyway,
My lord will
get
just
the
see.
Xerox.
Which page?
Get the Xerox.
21 crores.
So what is this?
Don't copy the.
So what you are suggesting? What you are suggesting from this?
For what I'm suggesting from this is net payment. The imposition of penalty is subsumed in this amount. Penalty, even if it is assumed that some penalty was imposed, it is part of this. And after imposition of penalty, net amount has been released, 21 crores. That is being distributed now by the learned arbitrator, 61%, 39%, which means penalty or payment that is released, whatever has been done, 61%, 39%. This is their own case. My lord has got that. This is what is my submission. They agreed with me in the evidence. In the same volume, at page 1124, question number 18, I put the same question to them. If the amount that is released is net payment after assuming penalty, that payment is
21 crores.
21 crores. Is including the penalty. After adjusting penalty, 21 crores has been released, and the learned arbitrator is disputing it 61%, 39%. I put it to him in evidence.
60% and 40%.
61 and 39.
61 and 39.
61 and 39. 61 to me, 39 to them. This 21 includes the penalty imposed. And in their evidence, they agreed with me. Today, a different stand is taking. 1124, my lord, in this third volume. My notes of cross-examination, where I asked them this question. Page 1124. Repeat. Repeat. Page 1124, question number 18. This is what I asked them specifically when they said, look here, penalty has been imposed. I said, well, penalty has been imposed and after that only amount has been released. No. They agreed with me. Question number 18. 1124. I put it to you that the payment released by the NILET to the respondent is after defraying the penal amounts imposed on the respondent. He says, yes. So the payment released by NILET is after defraying the expenses towards penalty. Their contention now is completely contrary to their own evidence. Therefore, my lord, my submission is this, that even the contentions relating to penalty are one, baseless, because there is no evidence of any actual penalty being imposed. And even if going by R73, some penalty appears to have been adjusted into the payment release, payments that have been released is after the imposition of penalty. So whatever is distributed, penalty or payment release, it is in the proportion of 61 to 39. And that is what the learned arbitrator has done. Well, again, the last submission I have, this contention of theirs, that payment of penalty needs to be adjusted, in law has to be understood either as a set-off or as a counterclaim. It can be mere pleading. It has to be demanded or asked in the form of a set-off or a counterclaim. There is no set-off, there is no counterclaim. In fact, this plea itself is not. They have neither claim set-off nor counterclaim. This plea also is not there. Therefore, my lord, what the learned arbitrator has done is, given the evidence as it is, given the issues that were framed, looking at the contract, you both agreed, whatever comes from NILET, 61%, 39%, take it. And that's all that the learned arbitrator has done. All these other contentions are an afterthought, that too after the section 34 proceedings, not even before the section 34 proceedings. The last contention, my lord, I had already responded in the beginning, that I have given up the settlement agreement because I have claimed the total amount. That is by under section 21 of the Specific Relief Act. I had pointed out that I have not given up anything. My claim is under the Contract Act, under the contract, Specific Relief Act section 21. I asked for specific performance of the settlement agreement 23 crores. And in addition thereto, I asked for damages of 14 crores. It coincidentally comes out to 37, means nothing. Well, I'm just concluding by this. I have given two sets of synopses. If my lord just can take note of that, that will assist the court. The first synopsis with my case laws, my lord, I had filed earlier in December 10th. And this. These two contentions which are being raised, for that additional synopsis I have filed now. My propositions, case laws are there in the earlier synopsis, and the reply to their contentions are in this synopsis. Therefore, my lord, there is no case made out warranting any interference by this honorable court in concurring judgments in my favor. Therefore, this appeal requires to be dismissed. I have pointed out 72 and R72, R73. I've also made a mention at 2.4, my lord, of their evidence in response to my question number 18. They have not raised any set-off or counterclaim. And the second proposition, that the contention that they seek to urge, that by having claimed an amount of 37, I have given the settlement agreement, I have given it to go by section 21 of the Specific Relief Act.
Therefore, my lord, the learned arbitrator has conducted himself well within the parameters of the contract, no cause for interest. Grateful.
I'm led by Mr. Raghavan, my lords. He's in an arbitration, as he mentioned yesterday, although, my lords, I have requested him to conclude the argument. My lords, I'm expecting him to log in on a VC from Delhi, my lords. If it's not possible, could my lords grant a date, my lords, for him to conclude with the reply argument, my lords. Mr. Raghavan,
You have to proceed.
my lords,
You have to conclude as your senior said yesterday.
very well, my lords.
Whatever you are not arguing today.
My lords, my request is that if a date could be given, Mr. Raghavan will address the concluding argument.
When your Mr. Raghavan is coming.
Lords, he's held up in a week-long arbitration, my lords. Any date upon reopening.
He said yesterday that he is not available.
Yes. Very well, my lords. Then I'll assist this honorable court, my lords. My lords, in reply arguments addressed by the respondent, by my learned senior for the respondent, to Varun, my lords. Please, may I continue, my lords? Please. My lords, in reply, apart from arguing the matter on merits, which the respondent themselves said they cannot be gone into under section 37 appeal.
Resume yourself to be Mr. Raghavan and Ari.
It's a tough task, my lords. I'll try my best. It's a lot of pressure, my lords, but
Then only you will be able to argue.
so
Otherwise, you said my senior is coming.
I'll try my best, my lords. I'm in my lord's hands. My lords, if I may just sum up in one sentence, my lords, the case of the appellant was twofold, my lords, or is twofold. One, my lords, is that the very basis of their claim, which is the settlement agreement, has been relied upon for their convenience in part and has been denied insofar as them wanting to go above and beyond that very same settlement agreement. For the 23 crore that they've claimed, they say the settlement agreement is valid and binding. For the balance 14 crore that they've gone above and beyond the 23 crore. It's the sum total of 23 and 14 being the 37.6 CR, which is the total invoice value. So this, I'm sorry, my lords, 23 crore, my lords, which is the amount of the settlement agreement, and 14.6 crore, which is prior C to their claim, which is above and beyond the money provided for in the settlement agreement, my lords. For these, for 23 crores, my lords, 23 crores.
My claim in damages was 14.6 crores.
So it is called, my lords, but it is just couched in clever drafting, claimed to be as damages. There is not an iota of pleading on loss. Therefore, it is nothing but a clever name given to damages, whereas in reality it was 23 crore as per the settlement agreement have to pay them. Till then, the settlement agreement is good because that gives them a clean chit of not proving that they've done the work. Insofar as the 23 crore, therefore, the settlement agreement was a very valid document. The moment they went past that stage, prayers A and B, when they came to prayer C, suddenly they said, no, settlement agreement was the product of misleading and inducement. We'll go above and beyond that. Even the balance 14 crore I want, but because I don't have any basis to claim it, I'll call it with the name of damages. And that's how they're seeking to justify it, my lords. In my humble submission, as learned senior argued, this is the crux of the issue, my lords. Therefore, my lords, put in one line, my lords, or one statement, their entire case hangs by the sole thread of the settlement agreement, my lords, and they have cut that very thread. That, my lords, gave them the protection from proving that they've actually done the work. So they benefited, and thereafter they reside from that very agreement. That's the first ground, my lords. The only other ground I've urged, my lords, in my note on propositions as well, is that the learned arbitrator failed to take into account the penalties, my lords. Now, my lords, in reply, as my lords have heard, and learned senior has addressed arguments, insofar as the first ground is concerned, approbation and reprobation, their only answer, my lords, before this honorable court is, it wasn't urged earlier. Nothing else has been said, my lords. Now, I'll address this with two responses, my lords, when they say that this hasn't been urged earlier, and I'll confine my reply arguments to that extent because learned senior Mr. Raghavan has addressed detailed arguments and my lords have been patient enough to indulge us. Lord, my first reply to this point on it hasn't been urged earlier, and learned senior was also fair to conclude somewhere here and there some words have been used. My lords, somewhere here and there, I would say, my lords, is at least better than nothing. And that plea was put forth by before the learned arbitrator, put forth in detail before the learned 34 court as well, but has been failed to be addressed. If my lords are pleased to take my note on propositions, I'll just point out, because this would be an incorrect submission to state that I have not urged it at all. This was clearly before the learned arbitrator, my lords, and pleadings speak for themselves. I may not have said in my claim, in my defense statement, of course, it's taken there and I'll point out that contention, but with the, my lords, the vigor and the detail in which Mr. Raghavan has addressed here, simply because that has not come out in the claim statement, the appellant cannot be held to have not raised that plea at all before the arbitrator. And my lords, they've completely neglected the fact that in their very own claim statement, they have said, settlement agreement is great for 23 crore, but I've also been induced to enter into the settlement agreement. So after this 23 crore is awarded to me, let's push aside the settlement agreement. Now give me 14 more crore. And in both these prayers, there is not a single plea that they have done the work. Now it's viewed from the parameters of section 34, where, my lords, if award is afflicted with perversity or going against the public policy, this, my lords, I would humbly submit is a case where, or the most basic notions of morality and justice on which I rely my pursuing this appeal, my lords, is the fact that even viewed from the most basic notions of justice, my lords, here is a respondent who stands before this honorable court and says, I will not prove that I have done the work. For that, I will only rely upon one agreement, settlement agreement. That very agreement also I'll attack. We are left in a scenario where, my lords, he wants money for work he has not done. Over and above that, he wants excess money by attacking the very same instrument on which he relies. And all of this is sought to be couched in their defense in this particular appeal with the simple statement, this argument in this much detail was not addressed before the learned arbitrator. There, my lords, I trouble my lords to kindly take up my note on propositions filed by the appellant, my lords. I'll just point out where this was raised before the learned arbitrator so that facts are clear and transparent before this honorable court. So it's not for the first time that this plea is being urged before this honorable court, my lords. Para 2, if I may just briefly mention, all of this is already mentioned, my lords, but because the submission came up, my lords, my note on propositions, my lords, it's just a single volume. Please, my lords. Para 2, if my lords are pleased to take. My lords, have para 2, please. Admittedly, the claim of the respondent was based entirely and solely on the settlement agreement. This is not in dispute, my lords. Even for once, during the multiple hearings before my lords as well, not once have they said, no, dehorse the settlement agreement. I am entitled to money because of the work that I did. That's not their case anywhere. Therefore, my lords, that is not in dispute. Now we need to see whether, my lords, if as learned senior says, I've never taken that plea before the learned arbitrator. Despite this, I continue, my lord, second sentence. Despite this, shockingly, the respondent has questioned the very same agreement by alleging as follows, para 8 of his statement of claim. Right from the get-go, from the pleadings, they have said, the italicized portion, my lords, I'm reading out. Respondent thus induced the claimant to enter into a settlement under which the claimant induced, my lords, word used, and learned see Mr. Raghavan also pointed out section 19 of the Contract Act, the effect of it. He has basically said that I was hoodwinked into entering into this agreement. Misled into agreeing. I have underlined and bolded those words, my lords. Into agreeing, the last few words, settlement agreement dated so words. In his very own case, he has said, my lords, that I was misled into. Second, my lords, the most critical factor here being, he has taken criminal action, my lords. On the very execution of the settlement agreement, he has gone to the police station, filed a criminal complaint, and that, my lords, while rest of that criminal complaint was read out.
Make my submissions.
I'm sorry,
I'm sorry, my lord, to interrupt. My learned friend was very keen that I should make some submissions. So can I have your lordship's permission to make my submissions, my lord? It's only if your lordships permit me.
Yes.
My lord, there are two questions that have been raised by my learned friend, on which, my lord, I want to make a short reply. My lord, one question that was raised as a point of law before your lordship is.
But Mr.
That-
Raghavan, your colleague is arguing very well. Why?
Of course, my lord. That's why I said, if your lordships permit me, I will do it. Otherwise, I will not. I will listen to what my learned friend is saying.
You are permitted.
Great.
Yes.
I am in your lordship's hands, my lord.
Yes, please proceed.
My lord. My lord, two submissions have been made at the forefront by my learned friend. One, my learned friend would say that the order under section 34.
We often change the wheel while traveling.
My lord?
Often we change the wheel of our car while traveling. So we understand that it is so.
I'm sorry, my lord, if I have.
Yes.
No, my lord, I am in your lordship's hands, my lord. If your lordship's permit.
This is on all. Don't take it seriously.
No,
Please
I understand. I understand. But the one question that has been raised as a point of law before your lordship is that even if the order passed by the commercial court under section 34 does not contain reasons, we must assume that the reasons
Yes.
the contention urged by the other side, my lord, is that even if the order passed by the section 34 court does not contain any reasons, it must be assumed that the reasons contained in the award is the reasoning of the section 34 court also, on the principle that the reasoning contained in the order passed by the original court is deemed to be incorporated in the order passed by the appellate court. My lord, as a pure principle of law, that the appellate court need not give reasons once again if it is concurring with the reasons given by the original court. My lord, I am not disputing it as a proposition of law. But in an arbitration situation, which is totally different, my lord, in its architecture, this principle does not apply. My lord, the proceedings under section 34 is the original proceeding. In fact, my lord, the cause of action for the section 34 petition is the award. The cause of action for the award, my lord, is the original cause of action, namely the transaction between the parties. Therefore, my lord, when a section 34 court is looking into the award, it is the first court. It is the original court. If the original court, namely the section 34 court, has given reasons as to why an award should be interfered with or should not be interfered with, having regard to section 34 of the Act, then, my lord, in section 37 appeal, the appellate court
if it is concurring with the order passed by the section 34 court, need not give any reasons. It can simply say, I concur with the reasoning given by the section 34 court. But that is not the situation here, my lord. Section 34 court is not an appellate court over the award. That is the established legal position, even on the principles, my lord, of the law that has been cited before your lordship by my learned friend, that the section 34 court is not an appellate court. Section 34 court is the original court. That is why, my lord, these section 34 petitions are in fact styled as arbitration suits. In fact, if your lordship will see the order, my lord, passed by the, it is styled, my lord, as a arbitration petition. It is not an appeal. Therefore, my lord, the section 34 court has to apply the principles laid down in section 34 in order to find out as to whether the award passes the muster of section 34. That is the requirement. And if that answer is given one way or the other by the section 34 court, then the section 37 court, namely your lordships, need not give elaborate reasons if your lordships are concurring with the order that has been passed by the section 34 court. That is the principle of law. Therefore, my lord, to now say that merely because the award has given some reasons, the section 34 court need not give any reasons as to why the award is right or award is wrong, is completely wrong, because the award is being tested. The award is being tested on the threshold of what is contained in section 34. That is the reason why, my lord, this honorable court came to the conclusion, passed the earlier order, which said that in a section 34 court, the section 34 court should set out the grounds and then, my lord, and then consider as to whether those grounds come within section 34. Now, my lord, please look at the order passed by the section 34 court, which your lordships will find, my lord. I just want to point out, your lordships, how all that the section 34 court has done is to record the submissions of the council and not go into it at all. Please be kind enough, my lord, to turn to page 49 of the appeal papers, my lord. Please be kind enough, my lord, to turn to page 51. That's where the judgment begins. My lord, para 2 sets out the facts, brief facts. Para number 4, my lord, sets out the grounds on which the award is challenged. My lord, it sets out all the grounds. Please be kind enough to turn to page 57, my lord. M. The learned arbitrator failed to consider the fact that the claimant on the one hand contended that the settlement agreement is enforceable, and on the other hand contended that the said agreement was a result of inducement by the respondent. Hence, the claimant is entitled for payment of the entire amount. Hence, the learned arbitrator erred in passing the impugned award without holding that the claimant is growing both hot and cold. Contention taken, contention noticed in the judgment, my lord, but without fear of contradiction, I can tell your lordships, my lord, that the section 34 court does not record a finding. And now, my lord, up to, and now kindly see para 5, my lord, states the objections. And now, my lord, para 6 at page 59. My lord, it is whether it is an arbitrable dispute, etc., is noticed, and allegation of fraud, that contention is noticed. And then, my lord, please be kind enough to turn to paragraph number 7, my lord, and then case law is considered. From paragraph number 7, up to para 15, case law is considered. Well, case law is referred, it is not considered. And then kindly see para 16. It is settled position in law that an award could be set aside if it is contrary to fundamental policy of Indian law or the interest of India or justice or morality, or in addition, if it is patently illegal. Then, my lord, para 70, the illegality must go to the root of the matter. And if the illegality is of a trivial nature, it cannot be held that the award is against public policy. Award could also be set aside if it is so unfair and unreasonable that it shocks the conscience of the court. Such an award is opposed to public policy and required to be adjudged void. This is all general principle of law. And then, my lord, para 18 sets out another judgment. 18, 19, my lord. Now kindly see para 20. Not one finding, my lord, on any one of the applicability of the grounds in section 34, which has been taken before the court, has been considered, and a finding given. Para 20, my lord. In view of the above mentioned discussions, the position in law is well settled that while dealing with an award under section 34 of the Act, the courts are not supposed to sit in appeal and reappreciate the evidence as an appellate tribunal. Hence, the findings of facts by the appellate tribunal, if based on evidence, even where there is a different opinion, can be held on the basis of that evidences. The findings given by the arbitrator has to be accepted, and the courts cannot substitute its opinion. The power to interpret the contract also lies with the arbitrator. Once the court reached the conclusion that the arbitrator has acted within his jurisdiction, even if the courts are of the view that the opinion of the arbitrator is wrong, the same cannot be disturbed unless it is against public policy. Again, my lord, general statement of law. It has nothing to do with the facts of the case. It has no relevance, my lord, in the context of the challenge that has been made to the award. And then, my lord, kindly see para 21. The applicant challenged this award on the ground that the arbitral tribunal has no jurisdiction to adjudicate the matter, and that, my lord, the court goes into on the question of jurisdiction. That is only a contention considered. Kindly see para 23. Again, my lord, it is the argument that is advanced. Whole paragraph, my lord, without fear of contradiction, I can point out to your lordships that this is only the contention of the learned counsel which has been recorded. And then, my lord, para 24, the contention of the learned counsel appearing for the respondent is recorded. Para 25, the High Court, my lord, the order passed by the this honorable court in the CMP is been recorded. And now kindly see para 26. It is clear from this order that the present petitioner has raised objection regarding premature institution of arbitration, but the Honorable High Court given a findings on this aspect. Further, till this day, the present petitioner has not challenged the said order and now come up with the ground that the institution of arbitration is premature, and on the same ground, the award is to be set aside. I am not, in fact, my lord, on that point at all. I am not on the question as to whether it is arbitrable, not arbitrable. I am simply on the ground that the settlement agreement under which 23 crores was agreed to be paid has now been given a go-by by the claimant in the claim petition, on the ground that that settlement agreement was induced by fraud and undue influence. That is where, my lord, I contend that a party who has given a go-by to a document cannot now rely upon the same document and say, give me an award, give me the benefit. You can't rely on one portion of a contract and then say the contract itself is bad on the other side. And now, my lord, please see, my lord, para 27. I rely upon the following decisions. My lord, from para 27, the judgments are quoted. Now, my lord, please now kindly see para 28. That is one finding that has been recorded. The finding, my lord, which is of no consequence so far as this case is concerned. Since the order of the Honorable High Court in CMP number so-and-so has not been challenged by the petitioner and it is reached finality, under these circumstances at this stage, award cannot be set aside on the ground of failure to hold the pre-settlement. I am not on that issue at all. This is a non-issue in the case. I never even contended that before your lordships. And my primary contention, my lord, is that if the claimant himself has given a go-by to the settlement agreement, as averred in the claim statement paragraph, which I've already pointed out to your lordships, how can a claim be made on the same agreement? And today, they claimed in the claim statement not only this 23 crores, but also the whole of the amount of their invoices. How do they claim both? The very fact that they claim the whole of the invoices without reference to the settlement amount itself indicates that they have given a go-by to the settlement agreement. That's the point, my lord. And where is that considered? Not a whisper about it in this order. And it is their claim statement that I'm referring to. I'm referring to the averments, my lord, that have been made in the claim statement where they say this is induced by fraud and undue influence, given a go-by. I am therefore, my lord, in the defense which I filed before the learned arbitrator, I said you can't enforce this settlement agreement. But no consideration at all on that. And now, my lord, please be kind enough to now just see para 30, my lord. Your lordships may be kind enough to turn to page 77 at paragraph number 30.
Yes.
My lord, all the case law is discussed, my lord, is, I won't say discussed, it is just set out and portions of it extracted up to page number 84. From page number 77 up to page number 84, simply an extract of the judgments of the various courts, including the Honorable Apex Court. Now, my lord, please see para 36. No reasons given. Para 36. In view of the above decisions, I do not find any intervention is required against the findings given by the London arbitrator on preliminary objections. Let us keep the preliminary objection aside, my lord. I am not now on the preliminary objection, and therefore the reference that was made or the reliance placed by the other side on the preliminary award or the preliminary order is irrelevant according to me. On the final award, what is the finding? Nothing. Now kindly see para 37, my lord. The petitioner has taken another ground to the challenge of the award that the London arbitrator failed to consider that Exhibit P1 was not a document that created a liability, and this is very important, my lord. Kindly see how, my lord, if I may respectfully say so without meaning any disrespect to the learned commercial court, my contention has been given lip service, if I may say so. I'll just read that, my lord. Kindly see. My learned friend said, oh, there's a finding. Where is the finding? The petitioner has taken another ground to the challenge of the award that the learned arbitrator failed to consider that Exhibit P1 was not a document that created a liability and the alleged dues were not payable by the applicant herein to the respondent without any independent evidence being adduced as acknowledgement of any debt or liability. The learned arbitrator further urged that a commercial suit in OS number so-and-so was pending between the parties wherein the respondent had claimed rupees so-and-so from the claimant while passing the impugned award. Hence, the award is liable to be set aside. These are all contentions. Further, learned arbitrator failed to consider the fact that the claimant on the one hand contended the settlement agreement is enforceable and on the other hand contended the said agreement was a result of inducement by the respondent. Exactly the plea that was taken. Hence, the claimant is entitled for payment of the entire amount. Hence, the learned arbitrator erred in passing the award impugned without holding that the claimant is blowing both hot and cold. When a contention is noticed, I ask myself, where is the finding? No finding at all. This is the crux of the matter. If a party to a contract wants to avoid the contract on the ground that the contract is vitiated by fraud and undue influence, I ask myself, can the same party be heard to say, give me an award on the basis of the same document? I may be right, I may be wrong, my lord, but I should have the satisfaction of my contention being considered. Otherwise, my lord, why do I want to come to court? That is the rationale, my lord, of the order dated.
That's all. Anything further?
My lord, basically, my lord, this is the primary contention. And in our note, my lord, we have given to your lordships the paragraph numbers of the claim petition where this plea has been taken, our defense, and the rejoinder, where, my lord, it's clear that this contention has been taken and, my lord, the contention is not considered. And that is the rationale, my lord, of this order dated 17th of April 2021, passed in commercial appeal number 25 of 2021. I strongly rely upon it. There's nothing else in this order, my lord, apart from that. And in our written submissions, my lord, we have pointed out to your lordships the paragraph numbers where contentions have been urged. And what my learned friend is saying is not correct, that the contention was not taken. But where is the question of taking a contention on the settlement agreement being induced by fraud and undue influence before the claim petition was filed before the arbitral tribunal? It is there that they took the contention. I didn't take the contention.
Yes. So we conclude.
Yes, my lord, I will not take your lordships. I won't detain your lordships, my lord. I have already made my submissions and it's already on record.
Yes, that's all. I will just keep in mind that settlement amount is 23 crores, 14 crores is separate as that. What they were contending. That is evident in my synopsis. The numbers and calculations are all there.
So heard learned advocate, Mr. Varun, please. Assisted by learned advocate, Mr.
Lords.
So heard learned senior advocate, Mr. Raghavan, assisted by learned advocate Varun for the appellant, learned advocate, Mr. What's the full name? Joshi?
Dhananjay Joshi.
Dhananjay Joshi, assisted by learned advocate, the respondent. At length, learned advocate parties submitted that they argued the appeal. Finally, they further stated that the pleadings were complete and no more are required to be added or supplemented. Resort for judgment.
Grateful.
Grateful.
Lords have been very patient. Grateful.
Thank you, sir.
Case number 109, Sharma Ayas.
Appearing on behalf of home buyers in laws.
This matter will take some lord at least some 15 minutes. I'll make my best effort to convince your lordships that the contempt petition, my lord, is not maintainable, particularly in view of one glaring fact, my lord. There is a section 95 petition, CIRP proceedings is admitted before the NCLT. And my lord, by virtue of section 96, Lord, may I just pass on this, my lord, by virtue of section 96, my lord, moratorium comes. They'll all have to go before, my lord, now the RP, resolution professional. May I just pass on this? How? If my lords could kindly have, my lord, the second page. The moratorium, my lord, during the moratorium period, any legal action, the interim moratorium under section 96, 1A of the IB code has commenced on the date of filing of this application. Whether financial creditor and will cease to have effect on the date of admission.
During such interim moratorium period, any legal action or proceedings pending in respect of any debt shall be deemed to have been stayed, and the creditors of the debtor shall not initiate any legal action or proceedings in respect of any debt. Resolution professional is directed to serve a copy of this report to the personal guarantor. Main debt is of the company, and my lord, everything is frozen. They are the only directors, 4 directors. And my lord, the IBC code, my lord, has been so careful in recent days, my lord. Personal guarantor cannot simply say this belongs to company and my lord, go aside and escape the resolution process. Likewise, my lord, the company cannot say this doesn't belong to me, it belongs to the personal guarantor and then can go. The NCLT, my lord, will look through.
So you're arguing appeal. Your appeal
My
is.
lord, the appeal is on one single premise, my lord. The appeal is at the time when, my lord, the order in the writ petition was filed, my lord, the party was, my lord, particularly the builder was not heard. Therefore, my lord, the appeal. And my lord, the contempt proceedings, my lord, which is now sought to be, my lord, included before this honorable court, is that a direction was issued, my lord, by the learned
Now the
single judge.
contempt will depend upon the outcome of the appeal.
Yes,
Let us see
appeal.
what appeal
Yes.
is. What is
And
it.
even, my lord, the appeal, yes, my lord, that is one submission. In view of the moratorium, my lord, everything comes to standstill.
Lords, with respect to the appeal, there is only one ground that they have not been heard. Lords, every single execution proceedings they have taken part, they have been heard in full. They did not appeal it. We have only approached this honorable court for execution of the orders. It has nothing to do with the respondent builders. Because they did not pay, we want it to be executed. What more they have to be heard, my lords? If they have some contentions, they can go for the appeal. There are more than 150 executions order. None of them have been appealed by the company.
In fact, my lord, precisely on this ground, precisely,
Lords,
my lord,
we are investors, my lord. We are home buyers. There are families for one person, there are only one flat that is available. We have purchased it. This is not a commercial property, my lord. This is a residential property which we have purchased that is 1 decade back. And now today they have initiated some bankruptcy code on their own and they are asking that my liability, we should all go back to, my lords, my only forum is RERA, my lords, where I'll get the quick redressal. Their fight is going on from 2021 and we are not aware of it. Today they are producing some papers. My lords, kindly go through this affidavit which they have filed, my lords. In the same contempt proceedings, they have filed affidavit on 18/4, my lords. Kindly see the page number 6. They have given a proper schedule on how they are going to pay this. They have made partial payment. It's not, their contention is not that they don't want to pay. They have made partial payment. It's all about the remaining payment that they have to give. 1.5 crore rupees has already been paid by them. And today they are coming up with a different argument altogether. Lords, in this
tomorrow, my lord,
Have a lot of personal inconvenience. The next working day, I'm aware, my lord, the meeting vacations are there, tomorrow being the last day. I have some personal, my lord, prayer, my lord.
My lord,
Lords,
my,
we have
the
some
EOP day, my
urgency
lord,
because this matter has been going on from past 1 year. They have filed affidavits. We were waiting on the affidavits for them to be complied. Now they are coming up with some new version. We don't know, after vacation, they might have filed something new and we are surprised by it. So.
My
It's-
residents need not have so many premises. They should have a nice Christmas and come back.
No, even my clients wants to have they don't have a home over their head, lords. That's the only issue.
My lord, my one submission with regard to the respondent authorities, the state, that is the Tahsildar and the DC, the contempt against them would not lie. Because with regard to the implementation of the RERA, my lord, we have taken action and that has been stayed in the writ petition, in fact, the notices. And whatever contempt, if it all lies, it lies against
I'm not even a
the
party to
financial
contempt petition.
establishment, because over here we are talking about RERA, implementation of the RERA. What is the implementation of the RERA to ensure that execution of the property or attachment of the property is happened? We have done so, we have issued notices, and whatever attachment, my lord, has been stayed, which has been produced also. And now
Milords, Milords, the state what they do, Milords, they issue japti notices and all other procedural aspects in someone else's name, claiming to execute these orders. Of course, the High Court has quashed those orders. It is nothing to do with our execution orders. It is not, there's a procedural lapse which they have done. That's why it has been quashed.
Really, my lord,
After
my friend
that,
wants Lord, execution orders, my lord, in a contempt petition which has been recently, my lord, strongly deprecated by the Honorable Supreme Court. Repeatedly, my learned friend is admitting to the entire intention of the contempt proceedings is execution. Execution has not been in place. It has been stayed by this Honorable.